That's 9:30. I'd like to make a start. Welcome to the second day of the proposed Crystal Rig Wind Farm inquiry. I don't intend to repeat my introductory remarks of yesterday or housekeeping notices, other than to say for the benefit of those viewing proceedings on the webcast that my name is Andrew Sykes. I'm a reporter with the Scottish Government Division for Planning and Environmental Appeals. My colleague Karen Hayward, who is an Assistant Chief Reporter, is sitting next to me. And together we have been appointed by Scottish ministers to hold an inquiry and report to them on the wind farm proposals. The ministers will consider our inquiry before deciding whether to approve the application. Yesterday we heard from the applicant's witnesses and from Mr Bruce, Chair of the East Lammermuir Community Council. Today we will hear from East Lothian Council and its witnesses. Now, given the unavailability of the Scottish Borders Council's landscape witness this week, it will be necessary to identify a mutually convenient date to reconvene the inquiry session. With this in mind, could I ask the parties to liaise and identify potential dates? About the availability of the hall and other venues that may be suitable. We can discuss this matter again before we close for the day. At the conclusion of today's inquiry session, we will move directly into the hearing sessions. We will consider energy and planning policy matters first, and then draft conditions. And if we're able to get through those sessions today, Ms Hayward and I would like to visit the application site tomorrow, if that could be arranged. And weather permitting, the viewpoints that we have discussed yesterday, although the weather forecast doesn't look good, I have to say. Could I ask you please to switch off your mobile phones or turn them to silent? Thank you. Now, are there any questions before we start? Mr Trinick.
Thanks, sir. Not well. One question to the reporters: if you could let us know your non-availability over the next few weeks, that would assist in coming to a schedule. Secondly, Mr. Gillis referred yesterday to a Bayes document on CFD. We have that for you now. The other parties already have it.
Thank you.
And we've also got hard copies of the Heathrow Court of Appeal judgment for you. Thanks, sir. That's it.
Borders Council, any questions?
No, nothing arising, sir.
Andy Slothy.
Good morning, sir. No questions. We're ready to proceed with our witnesses.
Okay, thank you. Can we hear from your witnesses, then, please?
First witness is Jean Squires.
Mr. Cameron, are you happy to Jean's that side rather than... Yeah, very okay.
Good morning, Ms Squires. Can I invite you to read your recognition from the beginning, please?
Yes. From the beginning. Okay. I was the case officer for this application. I have a postgraduate diploma in town and country planning. I've been a chartered member of the RTPI since 2002. I've worked at East Lothian Council, the council, as a planner for 19 years, living in the area throughout that time. The team I work for is responsible for preparing the local development plan and related work. I've prepared policy on both wind energy and natural heritage. I was a lead officer on the East Lothian Local Landscape Review, including production of supplementary guidance on special landscape areas. I've worked on the majority of the Council's responses to consultation on Section 36 applications. I visited locations around East Lothian, including the viewpoints in the EIAR at various times of day and evening. The four-light scheme. In preparing the Council's original response, I considered the merits of this application against planning policy and other material considerations. The Council objected due to the impact of visual aviation lighting and subject to sundry other matters generally adjust through conditions. The Council maintained its objection following submission of supplementary information. Fraser Gillis, for the applicant, emailed on 21st February 2020, stating that the Civil Aviation Authority had agreed to a further revised lighting scheme, requiring visible lights on only 4 turbines. This was followed up with revised visual information, including the applicant's table of turbines with visual aviation lighting. Visual information replacing figures JW1, JW6 and JW6A in James Welch's inquiry report, and figure JW10, a comparative ZTV. There are 2 main changes which arise from both the original and revised lighting scheme. Firstly, introduction of any light, even one, into a previously dark area. This is a distinct change from the baseline situation of no visible aviation lighting. A second level of change is the introduction of a group of lights into this previously dark area. The original scheme of 7 aviation lights had potential visibility in some areas of East Lothian of just 1 light, and in some areas a group of lights. The revised scheme has slightly reduced overall visibility of the aviation lighting in East Lothian in terms of both the total extent of the area affected and the number of lights potentially visible. In some places, the number of lights potentially visible has been reduced to 1, while in others, visibility of a group of lights remains. Verbal advice from our landscape officer on the revised scheme was that although the impacts of the revised scheme are reduced, its effects remain significant and adverse, and she maintains an objection. Her views were that the presence of lighting changes the character of a dark area of the Lammermuirs as viewed from the immediate area, in particular the B6355 road to Duns, and paths and higher ground in the area, as well as from views from longer distances, particularly from the north and the East Lothian Plain. I am aware from visiting locations in the area that aviation lighting can be visible over a distance greater than the 25 kilometres chosen for the study area, e.g. CD 10.9 figure JW1. Without making any judgment on significance, I am aware that from the Balfour Monument, OS map reference 35786067290, lighting of the Methil and Earl Seat turbines within Fife are visible some 33 kilometres and 35 kilometres distant respectively, as are the lights of the Forth Road Bridge at 45 kilometres. It's appreciated that these lights are 2,000 candela at all times. However, SNH in ELC 09 have provided evidence of the visibility of 64 candela lights at 18 kilometres from dark surroundings, and in image 3, 2,200 candela lights at 15 kilometres from brightly lit urban surroundings. CD 10.1, JW3 and JW4 and ELC 18 dark sky mapping show the limited areas of darkness in East Lothian, noted in 7.4 and 7.5 of James Welch's inquiry report. This is a valued quality. Protecting some areas of wilder land, including darker areas, was one of the aims behind designating the suite of special landscape areas as a whole. See page A21, CD 4.14. The Council sought to protect some dark areas because darkness was considered an important quality of the naturalness of an area. The view of the night sky is a joy free to all and equally part of everyone's natural heritage. Beautiful countryside, unspoiled areas, dark and wild land are not only important to those who live and travel here, but those who value them for their own sake. In addition to the planning consideration taken at the time of the Council's original response and response to supplementary information, I was also aware of the reporter's decision on the Gilston wind farm, which we received on 6 February 2020. In this, the reporter considered the applicant's reference to the climate emergency. There, the applicant noted a statement by the Scottish Government that transformative change is needed and that action has to be quick and decisive. The appellant argued that an emergency requires action and that decisions through the planning system must be responsive to that, which should be taken into account in the weight given to the project benefits of their proposal. The reporter, in that case, although acknowledging current Scottish Government energy policy includes considerable support for onshore wind farms, stated that that support is not unqualified. He continues, "It may be that the extent and urgency of the climate change problem will lead the Government to alter the planning balance in order to place greater weight on the benefits as against any adverse impacts. If there is to be a transformative change, this should be based on explicit Government policy." Given the Landscape Officer's views on the impacts of the scheme, and considering the recent comments of a reporter concerning the climate emergency on an application affecting East Lothian, I therefore considered that the Council should continue to object. We then discussed, that's me and Sarah Cheney, the landscape officer, the revised scheme and its remaining impacts with Keith Dingwall, Planning Service Manager, to whom authority to respond to Section 36 applications is delegated, and he agreed that the objection be maintained. Visibility. Dr Lumsden in CD 10.5, 5.7, considers how atmospheric conditions affect the length of time lights will be at 2000 candela, based on assumptions using comparison visibility figures from Lucas. No visibility measurements have been taken on the site. Lucas is a former RAF site located on an extensive flat coastal area, very topographically different from the plateau moorland of this site. Clouds can form when warm, moisture-laden air travels over upwardly sloping ground and is forced to rise, as here. ELC have concerns that conditions at the site could be very different from these figures, meaning lights will be at 2000 candela more often than suggested, and also that how the system detects poor visibility may also affect actual visibility. Some comments on inquiry reports submitted by Mr Welsh. Mr Welsh in CD 12.1, in particular paragraphs 6.27 to 638, comments on ELC's responses to the application. Dr Lumsden suggests that lighting on the cranes at the St James Centre can be discounted. By email to Mr Welsh, he confirms these are 2000 candela. Mr Welsh also suggests in his report that these lights are not relevant as their light spread is greater than that proposed here, and that they misrepresent the nature and intensity of light that would be experienced at Crystal Rig 4 due to the technology Crystal Rig 4 will use. Paragraph 3.25. In our original comments, CD 2.4, in referring to the lights on the St James cranes, the Council was not suggesting that the impact of the lights on the cranes was the same as the impact of lights in this application. Our aim was merely to state that these lights were visible and visible over some distance, as we have observed in the field. The context of the lights at St James is clearly different. They rise over the agglomeration of lights of Edinburgh. The lights of Edinburgh as a whole are clearly an important part of the nighttime view with or without the St James Cranes lights, which are a small component of the overall lighting scene, and actually, in my view, quite an attractive addition in that location. The introduction of lighting into the Lammermuirs, an area which has very little, if any, visible lighting, is clearly a very different effect, as Mr Welsh's report notes. I agree with the inquiry report that the St James Cranes lights are not relevant in terms of comparing impact. However, they are relevant in that they show that lights can be seen over a distance. In paragraph 3.26, Mr Welsh describes 2000 candela lights as just discernible at 25 kilometres. My impression is that they are more than this from observation of the turbine at Methil, the communication mast at Craig Kelly, noted in CD 12.3 as being 2000 candela and bright when viewed at over 29 kilometres from the B1343 to the north of the Garson Hills in Fife and the Forth Road Bridge lights, all viewed within the context of surrounding lighting. Where they are the only source of light in a dark sky, I would expect a 2000 candela light to be more rather than less noticeable. In addition, likely improvements in air quality may improve visibility over the lifetime of the proposal. I agree with Scottish Borders Council and Mr Welsh, CD 12.1, that there are currently likely to be fewer people walking about at night. However, over the lifetime of the scheme, numbers may increase due to improvements in technology, increased leisure time, more people in the area generally, or less travel to further destinations due to aims to reduce the CO2 emissions of transport. Mr Welsh refers to our comments regarding Viewpoint 20 that lights will impact negatively on the undeveloped and wild feeling of the area. He argues that there cannot be an undeveloped or wild feeling, as the baseline photograph for Viewpoint 20 shows around 40 wind turbines within 5 kilometres. However, the feeling of the area referred to in our response is that of the area at night, in the dark. The turbines, unlit, will either not be visible or be an indistinct part of a darkened scene. This is supported by CD 12.1, paragraph 8.3. The feeling of the area at that time of day, therefore, is of an undeveloped and wilder area. The darkness, the general lack of signs of activity, combine to give this area a wilder feel which in the daytime may be diminished by the obvious presence of the turbines. Mr Welsh's report, paragraph 6.31, makes no mention of ELC's reasoning for the objection to the aviation lighting, namely, the lighting of the proposed turbines will be visible from Outwith Dunbar Common and would not be visually contained by the Bowl landform. It would introduce a new landscape element into the nighttime view. It will break the Lammermuir skyline as viewed in the hours of darkness. No other development currently does this. These hills form the backdrop to East Lothian and are an important part of its character, as noted within the East Lothian Council's Special Landscape Area Supplementary Planning Guidance. Although the effects of the scheme are reduced, these impacts remain. Need for lighting. The scheme the applicant now proposes is based on an aviation report showing that the need for visible lighting may be based on the requirements of the operator of a single helicopter. The Council therefore questions whether further mitigation, even to the point of removal of need for all visible lighting, could be achieved, for example through equipping the single operator with NVG equipment. Summary. Although the effects of the scheme have lessened in quantitative terms, the principal reason that we objected remains, namely the impact of introduction of lighting into a valued dark landscape.
Thank you, Ms Squires. With the reporter's leave, just a couple of questions. If I can refer you to paragraph 2.6, in the third line there, you refer to being, without making any judgment of significance, I'm aware that from the Balfour Monument, lighting of the Methyl and Earl Seat turbines within Fife are visible, for some 33 and 35 kilometres distant, respectively. You'll recollect that Professor Lumsden in his evidence yesterday said that he could not see anything in the Earl Seat area. Are you able to provide any explanation or comment on that, please?
Yes, the reason that we mentioned that was to show that the lights were visible at that distance, and also that the landscape character of Fife was different because it was affected by aviation lighting. The lights that we thought we saw, we assumed were Earl Seat because they are in that general direction. They may or may not be. I have to accept what he said, that he couldn't see them, but there are red lights, one of which is flashing and which we thought was Earl Seat. I stand corrected if it isn't, but there is something of that genre in that area.
Thank you. And referring to paragraph 3.1 of your recognition, you referred to the comparison that was made with Lookers. You'll recollect there was evidence yesterday referring to SDL Muir. When did you become aware of that evidence?
Recently, after we wrote the precognitions.
Could it have been as recently as the start of this week?
It could.
No further questions.
Mr. Kirk, do you have any questions or points of clarification for the witness?
No, I don't think so. Just possibly just one, Ms Squires. Obviously, I appreciate that you're here wearing your East Lothian hat, so I take it you haven't had an opportunity to assess any of the viewpoints from the Scottish Borders area.
No, we didn't, because we thought the turbines are in Scottish Borders Council area, and I think we would have looked at views where they were a good view of East Lothian. So I suppose what we would consider is we would consider views from East Lothian to development in East Lothian, and also views from Scottish Borders of East Lothian. So I think we did look at some of them.
And viewpoint 13, I think Redstone Rig.
Redstone Rig.
That's in East Lothian.
Yes.
And what's your assessment of the impact that's likely to occur there?
That would be a landscape matter.
Apologies, I was forgetting your reply. I'll withdraw that question. Nothing further.
Mr. Trinick.
Thanks, sir. Good morning, Mr. Squires. The reason I suggested moving isn't because I'm going to there's any sort of intimidation which can sometimes be the reason for separating advocate and witness, but because we are going to get feedback.
Right, do you want me to?
We did yesterday. That wouldn't be a bad idea, if you wouldn't mind. I think to move that, because it's going to happen. It's going to be annoying.
Okay.
Yes. Thanks. That's better. Starting with LC, they were flashing lights where you saw there that you thought were the LC turbines.
At our seat, there's yes, we think there's one that looks steady and one that flashes.
Oh, okay. Well, if they're not LC, we don't know what they are. Then there's something but unknown.
No, I think they would actually. I think they would be too. I had a look at the planning application consent for Earl Seat, and it does say that they can put service lighting on the turbines. The non-technical summary says 25 candela, which I assume you couldn't see from that distance. So they therefore must be something else. We tried to have a look at the AIP list that I think
Can
it was
you go a
James.
bit closer to the microphone?
Sorry,
My apologies.
we tried to have a look at the AIP list to see what they could be,
Yeah.
but it's not presented in a very user-friendly form, and we couldn't manage to do it in the time available.
Oh, it's an unknown. We don't know either. That was an open question. If you go to paragraph 2.6 of your precognition, please. You tell us about the SNH images produced at ELC09. You might like to go to those, please.
It might be quicker.
If there are hard copies, it's going to be a lot quicker.
Thanks.
That's great.
Ah, got it. Got it, yeah.
If you go to image 4, which is the photograph of the lights that were on the Herefordshire wind farm in Murray, you tell us that at the bottom of page 2, paragraph 2.6, however, SNH have provided evidence of visibility of 64 candela lights. That's why I thought it must be image 4, because only image 4 has 64 candela lights. So I think that's the image we're looking at there, at 18 kilometres. I'd invite you to accept, looking at the page with the image on it, that actually this photograph is at 4 kilometres, not at 18.
They do look quite close to be at 18.
Sorry?
They do look, in that image, they do look too close to be at 18.
It's what it actually says on the paper.
Yeah.
Herefordshire wind farm from 4 kilometres. That image is at 4 kilometres, not 18.
That's, yes.
As a matter of fact, I'm just trying to get it clear.
Yes, I think it's that they also said that they were visibility from Davamur at 18. They were visible from Davamur at 18.
I'm sure they were, but I'm just getting in your evidence, it's getting clear that the image is at 4 kilometres. That's fine. And no doubt they also said they were visible at 18 kilometres, but that's another matter. And do you know, did you go and look at these lights yourself? Well, they were still up there.
No,
And you know they were flashing lights?
I believe so.
Yeah, okay. And I think, you know, you've produced the planning information for this project. We didn't go to it, but I think we can agree that the reason for the imposition of a lighting condition related to MOD requirements, not civil aviation requirements.
I'm not aware, but
Well, the turbines are less than 150
less than 100,
metres.
so that would be the case,
it will
assuming
be
there's
the
no
MOD.
aerodrome nearby, yeah.
Okay. At all events, they've now been replaced by infrared lights, I understand. Has that actually happened, you know, yet, or was it just consented?
I don't know.
I don't know. That's okay. Going on to the ELC09 photographs, if you could get those in front of you.
Is that the same ones, the LC09?
Sorry, 06, my apologies. 06, your own series of photographs, and again, I think you need hard copy. I'm really only interested in pictures 7 and 8, for the purposes of my questions anyway. And you remember that Professor Lumsden spoke to them yesterday.
Yes.
And there have been email exchanges on this, but for the reporter's note, what can you tell us now about the contextual information which makes a photograph more usable, such as what time of day, what was the exposure, length of the shot, what lens was used, was the image manipulated after the event? You can't tell us.
For these photos, no, we don't know because we...
That's okay. Thank you. Now, if you turn to paragraph 4.2 of your recognition, the St James cranes, which have come even better known than they were before in this inquiry, some mentions and dispatches. You heard what Professor Lumsden said about the difficulties of using the lights on those cranes as any kind of surrogate for the lights which are proposed for Crystal Rig because of the position of the jibs, the movement of the cranes, the angle of the light which varies from time to time. I know that you say very fairly, look, we're not trying to equate impacts here, and I get that totally. But I would ask you to accept that so far as the reporters are concerned, there is very limited value in looking at the St James's lights at all.
I think there is a value in looking at them because they form part of a very different landscape character, which my colleague may comment on, showing that the lights in Edinburgh, for example, the well-lit Central Lowlands cover the topography, and the St James cranes are part of a well-lit landscape, which is very different from this landscape here, and they're part of that. I agree that, I mean, I have to accept, I'm not a technician, I don't know if they can get a light which will look very different, but I would think the point of that lighting is to be seen by an airplane, so you'd think at some points this lighting may have to be seen similarly.
Okay. Well, perhaps we can agree that at a very low level it's useful contextual information. They are lights, they're out there, but they are, on Professor Lumsden's evidence, are very, very different from the lights that are proposed at Crystal Rig 4. So the reporters must exercise a high degree of caution in using the St James's lights, indeed any of the other lights on which Professor Lumsden gave evidence, as useful surrogates for Crystal Rig 4.
I would agree that the effects of the St James lights are very different in the location where they are because they're not surrounded by darkness, and it probably isn't comparable.
All right, that's very fair. Would you go to paragraph 2.4, please, of your recognition? And you also get out Mr. Welch's inquiry report. Do you have that? Actually, while you're getting documents, I'll tell you the other ones you'll need before the end of this exercise, so we can get them all at once. There is actually only one more, and that's CD 14.2, if somebody could get that out for the Squires, please. If you go, when you've got it, to paragraph 636 of Mr. Welch's inquiry report at page 39, where he rehearses I think it is your writing here, your concerns, fundamental step change into views of the Lammermuir Hills, including, and then there are a list of places: northern coastal plain around the coastal settlements of Whitekirk, North Berwick, Gallane, coastal tourist route of the A198, and from the higher ground of the Tranent-Elphinstone Ridge and the related settlements of Tranent and Elphinstone, as well as other places. So far as the four turbine lighting scheme is concerned, as opposed to that which you were assessing then, have you taken the opportunity to see what effect removing 3 lights has?
From the 4 scheme or from the 7 scheme?
Sorry? Have you taken the opportunity to review what effect the removal of 3 lights from the lighting scheme has on some of the impacts which you describe in your report?
From the original 7 scheme?
Sorry?
From the original 7 scheme, removing 3 from the 7.
Yeah, the reduction
not,
from...
not 3, yeah.
Sorry if I wasn't clear. My apologies. In particular, would you look at the Tranent-Elphinstone Ridge? If you look at, you'll need...
We'll need.
Can you be provided with JW1 amended? The big A1 drawing. You'll need that. I don't think that's going to look that clear on screen. My apologies. Also, you'll need the unamended JW1 as well. So both series. To give you a fair comparison.
Thanks. That's the original JW? Yeah, that's the original.
It's 1010, isn't it? The original. No, 10-1. It's CD 10-1, if that helps, Ms. Jane. For the unamended one, there we are. That's very kind, sir. Thank you. What I'm going to ask you to do is just briefly to compare the ZTVs in the area of Tranent and Elphinstone at about 25 kilometres. In fact, Tranent's on the 25-kilometre line, way off to the west, obviously. And you can see that the ZTV coverage of that ridge, the ridge about which you had concern, we can agree, can we, that visibility has been almost removed. In fact, I think entirely removed from the ridge. Would you agree?
Sorry, I'm sorry. No, it hasn't completely gone from the ridge. But I mean, it's clearly less than it had been.
Does that really remain an area of concern, that tiny patch of potential visibility?
I think it's actually, well, when you can see it at all, I think you would see it from there because it is quite an open road. I mean, it's obviously a long way away and a very small element of the view, but it is a landscape matter. So,
my difficulty is that actually both you and Sarah Chain do give, to some extent, landscape and visual evidence.
Yeah.
So I'm entitled to cross-examine on what you say.
Of course, yeah.
And indeed what you said in your report, in the report of handling. So it's a useful exercise in calibrating your approach for the benefit of the reporters. Are you saying that from your perspective, and I'll ask Sarah Chain as well, that any available views from that ridge at 25 kilometres are of concern to East Lothian Council? I
would say the general understanding of that area as lit rather than not would be, and that is part of that, how people would build up their idea of that area.
Not really answering my question. Are you telling me that the remaining theoretical visibility shown on JW1 amended from that ridge is of concern, well, to you as a witness at this inquiry?
It's obviously a very small element of the view, and I think it's unlikely to be that noticeable. So I think probably not, especially, is my personal view.
If you go to your precognition, please, at 4.4. I was intrigued by your reference to what might happen over the lifetime of the scheme. Numbers may increase due to improvements in technology.
Sorry, I missed. You're going a bit fast for me, Mr. Trinity.
Oh, sorry.
What paragraph number are you on now?
4.4. Second sentence. However, the lifetime of the scheme, that sentence. I could have left this, I guess, but I was just intrigued to know whether you had any evidence base apart from pure speculation for the comments you make.
I would say that I would think it's well known that government is trying to improve air quality, and that you would think would improve visibility. It's also got an agenda around equalities and diversity, which might lead to improvements in safety for women walking at night that might make them more likely to go out when they now don't. There's, I guess, just general technological improvement might help with that as well, because people don't get lost the same, so they might be more willing to go out at night than they are now, because they know they can find where they are, they can call for help if they get lost. Perhaps they can see better, they have better maps, so they might be more inclined to go out and enjoy the beauties of the night than they are now. Because obviously there's risk involved with doing that now, but that may reduce in the future. The East Lothian local plan asks us to allocate a quantum of housing, it's around 10,000 I think from the last time. That is going to lead to more people being in the area. There's a known agenda around reducing travel, which would mean perhaps people won't be going on the foreign holidays that they used to, and maybe more inclined to use the Lammermuirs. They might be more inclined to go there because to avoid long car journeys. Yes, it is speculative. It is speculative, but I think it's based on well-known trends. I haven't put anything into evidence of that, but. Well, increased.
It's some hit and miss, this, I have to tell you. It's not always coming on, this one. I'm not knocking any speculation. You're entitled to do that, and reporters will give such weight to it as they see fit. But I was just checking whether there was any current evidence base which indicates an increase in the number of people walking around at night.
Again, I could only evidence myself and my dog, which I take out last thing at night. So I mean, you do see people out. The rangers take a walk. They take a night walk along in midsummer. They walk through the night along the Lammermuirs. I don't know if there's been any increase in uptake on that. I don't know. I know they've been running it for several years.
It was me. It wasn't the button. I'll try and remember. Paragraph 2.5 of your precognition, finally, you'll need JW1 again. You've still got the big A1 map there, amended. So the four turbine lighting scheme we're looking at now. That's not quite the last question.
I have it.
Got that wrong. You say in talking about 2.5, and you refer to the views of Sarah Chain about the immediate area, in particular the B6355 road to Duns and paths and higher ground in the area. Now, I can go with Sarah Chain to this if you say that's her direct evidence rather than yours. Once you've gone, you've gone. So would I be right to direct questions about this to her and not to you? That's fine, as long as I know. Thank you. Finally, if you go to CD 14.2, it's a question which is slightly off the agenda, but it's the only time I got to tackle it with you. This is a statement of agreed matters with track changes showing where we disagree with you. And it's only one question, so don't these people think I'm getting into a policy area, because I'm not. But
sorry, Mr. Trinick, I wonder if that's the right document number. That's
14.2.
That's the draft schedule of conditions.
Well, I have it written down as the statement of agreed matters. Let's just check. No, it is the statement of agreed matters, East Lothian Council.
Will I need one to look at?
I think two documents have got the same CD number. The conditions is also CD 14.2, and I have now found the East Lothian Statement of Agreed Matters too. Okay.
Perhaps add that one of the reasons why some of the questions put to the East Lothian witnesses may not be as comprehensive as they might be is that I've also got Catherine Andrews, and there are some common questions I could have put to either witness, and I choose to put them to Catherine Andrews as being the landscape witness for the council which hosts the turbines. But that's my choice. But they'll come later, some of the questions that I might have asked of these two witnesses.
Okay, thank you for that. Okay. Your next witness, then, please, Mr. Campbell.
Can I just ask a question to clarify?
I beg your pardon,
Yeah.
yes.
It's just really on one point. You've been asked about the view from Trinent and Elphinstone and the effect of the revised lighting scheme going from 7 to 4. And is it fair to say that you've had very limited time to analyse the revised scheme because you only became aware of it on the 21st of February?
That is the case.
But nonetheless, did you actually carry out a visual inspection from that area?
I have passed it and looked at it in passing since we received this the new material, but I haven't carried out a landscape assessment, which is the landscape matter to do.
Thank you. No further questions.
Thank you, Ms. Squires.
Campbell.
Thank you, sir. Good morning, Ms. Jane. Can you have your recognition before you, please, and can you begin reading it from paragraph 1.2? Thank you.
Good morning. I was the lead member of staff in carrying out the East Lothian Local Landscape Review, reviewing the landscape character areas of East Lothian based on the ASH study undertaken for Scottish Natural Heritage in 1998, and identifying and designating special landscape areas within East Lothian, including identifying the special qualities and features of each area and writing their statements of importance. I was also a lead member of staff in production of the Council's Green Network Strategy. My team has built up expertise in appraisal of wind farm applications affecting East Lothian, including both on and offshore wind farms and wind turbines in adjacent areas visible from East Lothian. I provided landscape advice for East Lothian Council to the Falago Rig Wind Farm Extension Public Inquiry in 2017. I provide advice on landscape and visual matters across a wide range of planning applications. I have led training workshops and gave a talk on special landscape areas at the Sharing Good Practice series run by Scottish Natural Heritage. I have lived in East Lothian for over 13 years and have a good local knowledge of the area that goes beyond my working life. I have visited the viewpoints within the EIAR at various times of day. The original application was for 11 wind turbines, including visible aviation lighting to the tallest 7. East Lothian Council raised concerns about the visibility of this lighting to the applicants at pre-application meetings. No information was submitted with the application on any request for a dispensation of the requirements of the Civil Aviation Authority, and 7 visible lights were still proposed. East Lothian Council asked for the applicant to discuss the requirement for lighting with the CAA. This can be seen in CD 3.1. The application, when submitted, included proposals for physical shielding to remove lighting spread below -1 degrees. It's noted in CD 12.1 at 6.14 that physical shielding is no longer being considered as an option, as this could have required a plate of 11 or 12 metres in diameter. The application submitted for the inquiry relies on the lens design to reduce lighting spread below -1 degrees. Although, as proposed, this does not eliminate spread below this -1 degrees. It should be noted that although the proposed light beam is narrow when limited to the height of a room, as shown in CD 10.2 Figure 2, at 5 kilometres the 4-degree angle beam will be 349 metres wide, and at 20 kilometres will be 1.4 kilometres wide. This is a wide area over which the light will spread within East Lothian, as shown in CD 10.9 JW1. The option of radar-activated lighting has been dismissed without evidence to support the reasoning. The applicant submitted a suggested reduced lighting scheme to the CAA only in February 2020. We question the applicant's delay in consulting the CAA. The CAA, CD 618, has agreed to the reduction in proposed lighting to visible red 2,000 candela lights on the hubs of 4 number turbines, numbered 1, 3, 6 and 7. At present, this appears to be the applicant's final position. Although the reduced lighting scheme shows theoretical reduced visibility of the turbine lighting, CD 1010 and JW10, across some areas of East Lothian, this proposal has not recommended removal of all lights and therefore does not appear to address East Lothian Council's objection. This recognition concentrates on the landscape and visual impact of the scheme, with 4 number proposed visible aviation lights on East Lothian. East Lothian sits on the east coast of central lowlands Scotland, on the northern boundary of the southern uplands. It comprises distinct landscape character types, roughly forming 3 linear bands north-east to south-west across the area. The coast to the north and east, agricultural plain to the centre, and upland hills to the south. Settlement and main transport infrastructure are located within the plain, contrasting, particularly at night, with the darkness of the very sparsely settled Lammermuirs to the south. The importance of the landscape character of East Lothian at not only a local but also regional and national level, and how this should be protected, is identified in the Special Landscape Area Supplementary Planning Guidance and detailed in paragraphs 2.6 to 2.9 of East Lothian Council's response to SNH consultation of 14th of August 2018.
If I may just stop you there with the reporter's leave, Ms Jane, and invite you to read from ELC 23 the paragraphs that you quote, paragraphs 2.6 to 2.9, on the basis that I think this would assist the inquiry, the reporters and parties. So if you could have that document, everyone could have the document before you, ELC 23.
I do. Right.
If you could read from paragraph 2.6, please.
Okay. The importance of the dark baseline, as identified by Scottish Natural Heritage, is shown by our Special Landscape Area Supplementary Planning Guidance, where page A21 in CD 414 notes the purpose of Special Landscape Area designation is part of East Lothian's All Landscapes approach, and one of its aims is to safeguard and, where relevant, improve important landscapes and landscape features which are particularly valued. It also notes that one of the intentions in selecting sites for protection through designation as special landscape areas includes to protect some areas of wilder land, including darker areas. The importance of the enclosing edge of the Lammermuir Plateau, as identified by SNH, is shown in the Special Landscape Area Supplementary Planning Guidance at page A14, which notes that there are some regional landscape features and elements which characterise eastern coastal areas of lowland Scotland, the central lowlands or the southern uplands of South Scotland, which help maintain the distinctiveness of these areas in relation to the rest of Scotland or the UK. To maintain the distinctiveness and sense of place of these areas, it is important that the features that typify them are conserved or strengthened. The Supplementary Planning Guidance identifies the southern upland boundary fault and hill ridge skyline as characteristic of the central lowlands and therefore of regional significance, with the Lammermuir skyline identified as an example of where one of these features is distinctive to East Lothian. The Special Landscape Area Supplementary Planning Guidance at page A15 notes that consideration should be given to protecting and enhancing landscape features and elements which characterise the wider regional distinctiveness, including of the central lowlands, and includes two recommendations relevant to this inquiry on page A16. Number 1, development should not impact on the appreciation of the southern upland boundary fault as a single feature. Nighttime views of the Lammermuirs reflect the current lack of settlement within this area, with very little light on the northern downslope. Development should avoid use of colours or materials that would lead to it stand out, especially when viewed from the East Lothian Plain or outcrops below. Number 2, any proposed development must conserve the unbroken horizontal element of the Lammermuir skyline, especially as viewed from the plain and foothills below. The distinctiveness of the skyline is further identified as a special quality and feature within the Lammermuir Moorland Special Landscape Area. Point 3 says the Lammermuirs form the backdrop to East Lothian, an often dark band with a strong horizon line contrasting with the lighter, more varied colours of the fertile farmland below and the open sky above. The skyline, especially where unbroken, characterises East Lothian. Although set back from the Lammermuir edge, higher parts of this area form skyline as seen from the plain and foothills below, both in East Lothian and the Scottish Borders Council area. This specifically notes in its guidelines for development at point C, any proposed development must not harm the unbroken horizontal element of the Lammermuir skyline, especially as viewed from the plain and foothills below, and for key views from the Scottish borders and within the Lammermuir Hills themselves. Development should be located and designed to limit wider visibility and protect the unbroken horizontal element of the Lammermuir skyline.
Thank you. And can I ask you now to resume...
Excuse me, Mr Campbell. Can I just say before you proceed that we don't appear to have that document before us?
ELC 23.
23. It was the response to the SNH consultation.
I was under the impression that was a core document. I do apologise. I wasn't aware that that wasn't available to parties or the reporters.
Don't you have it either, Mr Tunick?
There's no need to apologise, Mr Campbell. It just wasn't in the this bundle, but actually I have got it. I've been past it, so my apologies.
We don't have it.
I'll make arrangements to make it available to you, sir and ma'am, as soon as possible, and I apologise for you not having it just now.
Okay, thank you.
There is going to be a further reference to it in the precondition of Ms Chain. So if we get...
CD 522.
No, sorry, we don't have that either. Don't know why. I'm not sure it's... I think it might be a mix-up in our office, to be honest.
I found a copy.
I think it's our fault because it's not been put onto our laptops. So thank you for your apology, but you didn't need to make it.
Okay, I'm sorry for the interruption. If you'd like to continue. Okay.
Thank you, and I'm sorry about that confusion. That any responsibility was our part, and I appreciate Mr. Trinning's assistance. Thank you. Ms. Jane, if you can resume reading from your precognition at paragraph 4.3, please.
ELC 18, together with CD 10.1, JW3 and JW4, show the lack of perceived development within the hills and the associated darkness. ELC 18 Map 2 clearly shows this at national level along the line of the southern upland fault. This creates a clear distinction at night time between the landscape character types of plain and uplands. The skyline is visible on moonlit nights, and the darkness of the hills has a different quality to the sky at night time on non-moonlit nights, when the matte of the hills contrasts with the starlit sky. Photographs from Dr. Lumsden at CD 10.4 D1, D5 and D7b show the dark linear band of the hills, broken only by the example light, beyond the settled and lit plain in the foreground. Figure D5 also shows how close the wind farm development is to the northeastern end of the southern upland fault. I therefore disagree with Mr. Welsh's statement that the loss of important features and composition of the view are not readily discernible at night. I do not agree with Open's only criteria for visible aviation lighting being the level to which the aviation lighting comprises or diminishes views of the night sky. The impact is on landscape character and loss of distinctiveness, not just on views of the night sky.
Just to clarify, I think it's compromises in the third last line of that rather than comprises.
Oh, apologies. Compromises. The Special Landscape Area Supplementary Planning Guidance identifies 3 aims and 8 intentions for special landscapes in East Lothian, including protect some areas of wilder land, including darker areas. Although not within a designated dark sky park, the Lammermuir Hills are valued for their darkness. As ELC 18, CD 10.1, JW3 and JW4 show, areas of darkness are limited in East Lothian. The hills provide areas of undeveloped open character, with darkness being one of their important characteristics, as defined in CD 414, SLA 1, pages A26 to 12. In close proximity to large areas of population and easily accessible compared with more remote areas of Scotland. Pictures 1 to 9 in ELC 6 show use of the hills, particularly at night. In Appendix B, East Lammermuir Community Council notes responses to their consultation. Light pollution will spoil the wonderful dark skies area for stargazing. Aviation lighting would give the area an industrial appearance. Paragraphs 11 and 12 of ELC 11 discuss 2 of the viewpoints within the hills from East Lothian, where local residents, and not just recreation users, will be impacted daily by lighting. CD 10.5, Table 1, page 17, shows at midwinter that sunset can be as early as 15:36 and sunrise not until 8:40 a.m., with aviation lighting being turned on at 16:06 and not turned off again until 8:10 a.m. The aviation lighting would be on during commuting hours for many months. Views of darkness from East Lothian are limited. To the west lies the urban agglomeration of Edinburgh, including aviation lighting to tall structures of cranes and bridges. To the north lies Fife, with settlements along its shoreline and aviation lighting to its wind turbines and telecommunication mast at Craigkelly. Looking east will bring views of the approved offshore wind farm at Nartnagria, with 54 numbered turbines with aviation lighting, including 27 2,000 candela aviation lights to perimeter turbines. This increases the importance of retaining the darkness of the Lammermuir Hills to the south. SNH Guidance CD 515 at 213 notes that current experience suggests that the main landscape and visual effects of aviation lighting are likely to include lighting being visible over a considerable distance and movement of blades creating effects. It notes that these are likely to be more significant in areas with less artificial lighting, including remoter rural locations. Dr. Lumsden, in CD 12.2 1.3.8, notes additional light pollution also plays a role in determining significance of any light seen. The environment in East Lothian is darker than urban settings, therefore the impacts of the light is likely to be greater. Dr. Lumsden, CD 12.2 at 174-5, notes greatest impacts from lights at 5 to 7 kilometres, where they appear brighter than the brightest star, but not natural in appearance, being red. This is the same distance at the viewpoint 13 at Redstone Rig, on the only classified road through the Lammermuirs, where CD 12.1 at 8.55, using a revised assessment, considers the lights to have a significant visual impact. Dr. Lumsden, in 12.2, CD 12.2 at 1.3.7, notes contrast is important in how we see light. Contrast is high in the proposed situation as the hills are dark and light sources are being introduced into this dark landscape. S&H in ELC 23 considers where lighting is introduced into a dark landscape, the visibility of lighting will increase the overall perception of turbines in the landscape. In localised views, creating an adverse and significant visual effect due to its incongruity and location above the enclosing edge of the Lammermuir Plateau. The table at 1.6.11 in CD 12.2 shows that when visibility is poor, the 2000 candela light visibility drops away quickly and has visibility less than the faintest star beyond 12.5 kilometres. However, this table shows that a 200 candela light carries on being visible at a brightness of a medium star well beyond 20 kilometres, which is the limit of the table. The colour of the proposed light is not white or cream as a star, headlight or house light, but red, a colour that is used on tall structures specifically for warning. It draws the eye, as it should where required for safety. It will change perception of the view due to its colour and the viewer's association of this with its man-made origins, from a natural, dark, undeveloped one to one containing unidentified and unexpected built structures and lighting. S&H images 4 and 5 of ELC 09 show aviation lighting on turbines at distances of 4 and 5 kilometres and 64 candela and 32 candela respectively. These rural locations are similar in location and distance to viewpoint 13 at Redstone Rig. These lights, however, are much lower intensities than the proposed turbines, yet still character changing. The description of image 4 notes when the turbines are not visible in total darkness, the lights appear dissociated from the landform and difficult to rationalise. These lights have since been switched off due to complaints from the local community, detailed in ELC 16 and ELC 15. It should be noted in any site visit that the turbine on which the test light is erected is 8.6 kilometres from viewpoint 13 at Redstone Rig on the B6355, whereas the nearest proposed lit turbine is only just over 7 kilometres from this viewpoint. This viewpoint is also to the prevailing wind side of the turbines, and the blades will most often be seen passing in front of the lights from this direction, creating a flashing effect. I have discussed this further in paragraphs 210 to 212 of ELC 23.
Interrupt you again there, Ms. Chain. Are you referring to ELC 23 of the same document I referred to earlier, which I think we hopefully all have now? And can I invite you to, with the reporter's leave, to read out from paragraphs 210 to 212, please? Thank you.
Yeah. Paragraph 210. S&H goes on to note that some of the lights may appear to flicker where there are overlaps in turbines, as seen, for example, at viewpoint 13 B6355 Redstone Rig. We agree with this, as this viewpoint is also to the prevailing wind side of the turbines, and the blades will most often be seen passing in front of the lights from this direction, creating a flashing effect. A flashing effect attracts attention more than a constant light, thereby increasing awareness of the lighting. This flashing effect is likely to not be even or even in sync between the turbines due to the differing rotation of the blades and the effect of the blades of unlit turbines passing in front of lit ones. S&H make comment on the flashing effect of wind turbine blades passing in front of aviation lighting experienced at other wind farms. They also note that when the turbines are visible, the lights make sense, but in total darkness, when the lights are not visible, the lights are dissociated from the landform and are difficult to rationalise. The flashing effects on the turbines passing in front of the lights can be seen in the video ELC 19 of the aviation lights on the turbines at Neilston. This was taken in foggy conditions, and the lights are at 2,000 candela at a distance of approximately 500 metres.
Thank you, Ms. Jane. Can you just resume and complete your recognition now, please? Thank you.
The southern upland fault runs roughly in a north-east-south-west direction, defining and framing the more developed and well-lit central lowlands, in contrast to the much darker southern uplands. This feature is important in giving character to the central lowlands as a whole, not just East Lothian. The proposal will introduce a light source into the hills where darkness is identified as a defining feature. This will reduce the distinctiveness of this landscape feature, important at both a regional as well as a local level, and will therefore be contrary to East Lothian Guidance, CD 413, page A15. The introduction of aviation lighting, as proposed, reduces appreciation of the landscapes of East Lothian, in particular from within the hills, which are valued for their feelings of naturalness, remoteness and darkness.
Thank you, Mrs. Chain. I apologise, I was calling you Ms. Chain before. I understand you're Mrs. Chain. I have no questions. Thank you.
Mr. Kirk, any points of clarification you'd like to discuss?
Mr. Chain, I erroneously endeavoured to ask your colleague a landscape question earlier, and I see I was referring to Redstone Reg at that point, viewpoint 13, and you have referred to that, I think, on 3 occasions in your recognition. Have you been at that viewpoint?
I have.
Yeah. What is your assessment of the likely impact of the lighting at that viewpoint?
If I could refer you to the landscape response, if I could just find the document that we did to the original application. I noted that.
Sorry, do you have a document reference?
Sorry. The document number.
Just before we go on, I mean, Catherine Andrews does give evidence on this viewpoint, and I think we're in danger of a bit of friendly fire here.
I was merely seeking to establish that Stephen's evidence was going to be to. And I take Mr. Trinick's point. I'm happy to move on. I've no further questions.
Okay, thank you. Mr. Trinick, any questions? Yes, that'll be fine. Thank you.
Do the break. If I tell you the documents you need, it may save time when we resume. Be useful to have, obviously, the photo montages. That's volume 3C of the ES, which is CD 15C. CD 413 and 414, which are that's the SLA SPG document. 57, which is, double check, give you the name as well. No, not, you won't need 57. 58, please, the SNH visual representations document. 10.1, and that's the A1 maps, the original set of A1 maps produced by Mr. Welch. And 10.9, which are the amended A1 maps. And 12.1, which is the inquiry report of Mr. Welch. Those are the documents. Thank you.
Okay, we'll take a 5-minute break. Thank you. generous 5-minute break, I'll like to get things started again. So, Mr. Trinick.
Thanks, sir. Good morning, Ms. Cheney. Can you tell us something about the site visits which you've made at dusk and dawn to the viewpoints of concern to East Lothian Council?
We visited the site at Oldham in the evening. We arrived at around sunset and waited until the sun had set and witnessed the light coming on the hills, the temporary light that's been put there. We also went to the viewpoint, not the viewpoint, the White Kirk assessment point. But we visited the other sites within East Lothian, not visiting when the temporary light was there, but just at other times, and generally in the evenings.
And viewpoint 13?
Yes, viewpoint 13 at Redstone Rig. We've been there. Not since I haven't seen the temporary light up there, so it'll be interesting to see that at the site visit that we do next week or tomorrow.
Well, whenever we get some decent weather.
Yes.
So viewpoint 19, Whitekirk, you've seen the test light from those two places.
Yes.
And viewpoint 13, but not seen the light.
Yes.
Okay, that's very helpful. Thank you. Now, if you turn to your precognition, please. I'm going to rehearse a number of paragraphs for a reason, and we'll come to that reason. In 1.2, you tell us that you were a lead member of staff carrying out the local landscape review, reviewing the landscape character areas, identifying and designating SLAs within East Lothian. So you led the team doing that. Excellent.
Myself and Jean were the staff
Jean
involved in that.
Understand.
Right.
If we turn to 5.1 of your precognition, you tell us about the SLA SBG, and that's CD 414, we'll turn to that. And at 5.2, you tell us more about not designated as Dark Sky Park, Lammermuir Hills Valley for that darkness, and open undeveloped character, etc., and then more about the SLA, CD14, you tell us about. In 6.2, increases the importance of retaining the darkness of the Lammermuir Hills to the south. And that's in terms of the views which you describe in 6.1. So, and you've also, in your evidence in chief, you've read from your response to the SNH representation. So we know the importance you attach to the SLA and to views towards the SLA and the protection of that Lammermuir skyline. We know that very well.
Yes.
Absolutely. And let's therefore go to CD 413 first of all. And go, once you've got it, you're doing it electronically, I presume, reporters, are you? Yep, okay, fine. It is page numbered, I think, page A1-2. Landscape area, character areas defined by the East Lothian Review 2015. You've got the Lammermuir Plateau and the plateau with wind farms. So those are the two areas with which we're concerned here, aren't we?
Partly, we're also talking about the impact, the views of the hills from the plain.
If we go to a map on the next page, just for the reporter's benefit, we see the hatching, a lighter green hatching from southwest to northeast hatching for the Lammermuir Plateau, and then we can see Dunbar Common, a darker colour, that's Lammermuir Plateau with wind farm. Now, those are the areas I'm concerned about for the purposes of my questions. And we can see that the area, you can see the wind turbines there in the borders, and some of them in East Lothian. And the area I want to focus on is Dunbar Common, so we can see that. And you know where Crystal Rig 4 is in relation to that.
Yep.
Go to page A111. Here, for the reporter's benefit only, I'm not going to rehearse it in detail. We have, it's the LCA, isn't it, for the Lammermuir Plateau with Wind Farm, the area of Dunbar Common.
Yes, it is.
It says what it says. I don't think we need to rehearse anything in particular from that. Then we go to CD 414, if you would, which is coming out of Appendix 2 to the SPG about the SLAs themselves. If we go to page A21, which is the first page, we can see that, first of all, the purpose of designation, which I'll leave most of it to be read by the reporters, but at the bottom of the page, paragraph H, to protect some areas of wilder land, including darker areas. And you refer to that guidance in your evidence.
Yes.
Yeah. And then if we go to the relevant map, which is just before page A25, we can see the areas, the SLAs which have been designated, can't we? Yep.
Yes.
And we note that actually Dunbar Common is not designated.
No.
We'll come back to that. If we go to page A26, we come to the statements of importance for the Lammermuir moorland. It's SLA 1. That, although we're not in that area, and we're not primarily referring to the area, nevertheless that's relevant to the skyline experience to some degree. So we can note there on page A26 under overview, the key characteristics, second paragraph of the area is a sense of expansiveness and space, dominated by the large open area moorland, big skies, and then at the bottom of the page there are references to large-scale wind farm development at the adjacent Falago and Crystal Rig, visible from parts of the area.
Yes.
And then at the bottom of that page, A27, special qualities and features. Well, there we have it. Over to the next page, paragraph 3. Lammermuirs form the backdrop to East Lothian, often dark bound with strong horizon line contrasting with the lighter, more varied colours of the fertile farmland below, ... Although set back from the Lammermuir edge, higher parts of this area form skyline as seen from the plain and foothills below. And then if we go over to the following, yes. I think we can note without need to read it out, paragraph 8 about peacefulness and wildness, 9, reference to Michael's law, the highest point, and then some guidelines for development. And C, any proposed development must not harm the unbroken horizontal element of the Lammermuir skyline. Well, Dunbar Common was in, understand it, the old AGLV prior to its replacement by the SLA, am I correct?
Yes, it was.
Your microphone.
Sorry. If you look at ES figure 86, you'll see the old AGLV map then, because the time the EIAR was published, it was still an AGLV. So tell me, why was Dunbar Common omitted from the SLA?
The character of that area has changed with the development as wind farms. So that was why we felt it wasn't one of the East Lothian's special landscape areas anymore.
Let's look at figure JW1 amended, if you would. This is the big A1 drawing. And we look at, we can see the SLA because that's stippled, it's very, very clearly marked. I think the fainter black lines within the stippling are simply subdivisions of the SLA, is that correct?
They define the different special landscape areas.
Yeah, okay, that's fine. But it's all SLA, all the stippling. And then we come to the Dunbar Common, and we can see that the area of Crystal Rig 1 and 2, maybe parts of 3, I don't know, is undesignated. But then we come round to Aikengool 1 and 2, and they are designated. So that makes me rather curious about your answer.
It's not just the wind turbines, it was also the landscape form, where we looked at the...
Sorry, could you say that again?
It's also the landscape form. When you look at the area where Aikengool 1 and 2 and 2A are, they have a very different landscape character to the bowl of Dunbar Common.
In what way does that justify them being in the SLA but not Dunbar Common?
I would have to look at our technical report where we did the definition of it, but I could take you to the special landscape area for the Aikengool area and have a look at its special characteristics, if you would. That's within the special landscape area.
That's fine. It's within CD 414, is it?
Yes, yeah.
Fine. Let's take a look. Do give us a page number, if you would.
Yeah.
Will you bear with me? I just want to check the map a moment. So that's called Area 6, isn't it?
It would be Special Landscape Area 4.
4.
The Money Nut to Blackcastle, which is page A228.
Let us get there. Okay, I've got there.
Yes, I have it too.
Remember, what I'm after is the reason that Dunbar Common was not felt to be worthy of inclusion in the SLA, but and you've referred to the change in the character of development there because of the wind farm, and yet Aikengool 1 and 2 are included in the SLA.
That's right, because the landscape form of the area where Aikengool 1 and 2 are is, you can see in the special qualities and features, specifically number 2, where it says the area forms a complex contrasting landscape of a mix of land uses and features visually rich. So it was felt that the area of Dunbar Common didn't provide that.
Well, okay, but the word I was sort of looking for was skyline. We've read a lot about the need to protect the skyline of East Lothian from, in terms of views from the north. And Aikengool I can quite see is not on that skyline, but Dunbar Common is.
Yes, but that's mentioned in the previous SLA for the Lammermuirs. It's in the other SLA where we talk about the Lammermuir skyline.
I see that. I can see the different reasons. I see the reasons for treating Aikengool 1 and 2 differently. And what you've really just told me, I think, is that well, you have told me. You told me why Aikengool 1 and 2 are felt to be in the special area for designation. It's coming back to Dunbar Common, on which I want to focus now. The only reason for not including that area was the change in the character of the common and the plateau because of the wind farm. Is that right?
Not necessarily the only reason. What we didn't have any evidence for the reason for the areas of special of the AGLVs, the original AGLVs. So when we were looking at this, we were starting anew. So we're not sure why Dunbar Common was included in the original. The original AGLV ran across the whole of the hills. There was no designation to different areas. It's picking up on the different characteristics of the different areas. When we looked at the special landscape areas, we tried to look at the different characteristics of the different areas, which is why we've then designated different special landscape areas within different parts of the hills, as well as within the hill slopes. The hill slopes help to form part of the ridgeline, as well as the Lammermuir plateau. The Dunbar Bowl, although the edge of it could be described as forming the hill slope, would be picked up in the Danskin to Whitecastle special landscape area, which runs right up to the top of Bransley Hill.
That's where we disagree. That's probably where the reporters need to focus, and if they attach any importance to this point at all. If you look at JW1, you can see, well, you can't really see, but we know that the skyline extends along the northern part of Dunbar Common as far east as the northern tip of Aiken Gall, and then it goes off more to the east, the skyline. Going west, it follows, well, it goes around by viewpoint 18 and then continues southwest down the black line, which separates two SLAs. So for the whole of that skyline along Dunbar Common, we say that is the skyline. That is unprotected by any SLA designation.
Dunbar Common itself is in a bowl.
I wasn't talking about the bowl, I'm talking about the skyline to the north of Dunbar Common, that when you look up at that skyline from the north, the area you're seeking to protect, in terms of the skyline, what you see is not the SLA to the north. You are seeing the undesignated edge of Dunbar Common.
I would say that is designated within the Danskin to Whitecastle SLA that runs up to the ridgeline along the top. And then the following one, which is the Whittingham to Dukery SLA. The Dunbar Common itself is in a bowl and doesn't form the skyline.
A point of factual disagreement, I think. They're not sure how we resolve it, and the reporters will have to determine how important they feel it is. But this is a policy matter, of course, that there are policies, there is guidance which applies to the SLA which does not apply to Dunbar Common, and therefore, as a matter of fact, I'm trying to get to the heart of whether or not the skyline, when viewed from the north, that Dunbar Common skyline, is in fact protected as an SLA. And I guess I have to leave you with my suggestion that it is not.
I would say that it's within the landscape character area of the Lammermuir Hills and the plateau, and therefore it is protected under the same supplementary planning guidance, which we cover the landscape character areas as well as the special landscape areas. And I've specifically mentioned within my recognition about the protection and the guidelines for development for the area.
Yes, but I'm specifically concerned with the SLA, the designated area. And, well, I'm not going to repeat the point. I must leave you and leave the reporters for their note with our position that that skyline is not protected by SLA designation in terms of the important views that you see south from elsewhere in East Lothian.
I would have to disagree.
Let's illustrate the point by looking at two viewpoints, if you would. First of all, 19, Oldham. Let's just orientate ourselves. First of all, we know where viewpoint 19 is, and if we look at figure 817S1, Okay?
Yes, got that.
Are we... Thanks very much. If we look at that figure 1 first of all, we see that the skyline, a lot of wind farms along there, all named helpfully. Now the SLA starts somewhere between the Aiken-Gould group of turbines and the Crystal Rig group, doesn't it?
Actually, everything that you can see along that hill line is within a special landscape area.
Well, yeah, that's the point of factual disagreement. We say it's not. Looking on a north-south, if not, looking at between Aiken-Gould, however far the boundary of the SLA is set back, and that's disputed between us, the Aiken-Gould group is covered by the SLA designation. The Crystal Rig group is not. Correct.
The turbines of Crystal Rig are not within a special landscape area.
I think the reporters have got my point. The boundary between the SLA and the non-SLA lies between Aiken-Gould and Crystal Rig.
No, I'd have to disagree with that. In this view, everything that you see is within a special landscape area. The turbines at Crystal Rig are set beyond this view within the bowl.
Yes, I understand that, but in terms of deciding where within the landscape, subject to our point of disagreement, the boundary between the SLA and the undesignated area is Dunbar Common, we can see it's between Aiken-Gould and Crystal Rig. Our debate is, when we look at that Crystal Rig skyline, is it or is it not within the SLA? Correct?
No, I don't think so.
Okay, carry on.
Because from what I'm looking at in this view, the skyline is within the special landscape area.
Well,
There are several special landscape areas that comprise that skyline. If you look at the map on page A24 of CD.
Sorry,
14.
I'm losing.
If you look at the map on page A24 of CD, is that 14.2, the special landscape areas?
I think it's 414.
Is it 414?
I think,
Sorry.
isn't that right? So what page are we at on that one?
It's the page after A23. It's got the map of all the special landscape areas.
Oh, is that one right?
On that map, I think you can clearly see the skyline, and the edge of the skyline is defined by several special landscape areas, including 6, 8, 5, 3, and 1.
I understand your evidence. Our dispute as to whether the skyline itself, which you can't see on the map because there's no topography, is actually designated or not. We say not, you say yes. I'm not sure how we're going to resolve it, but that's a dispute between us. In terms of looking east-west, what I'm saying is, looking at figure 1, that whether or not the skyline around Dunbar Common is designated, the area around Aiken-Gould, which you can see the turbines of, clearly is, and that I'm simply leaving that point there. Turn, would you please, to figure 817S5 within the same series. And I know what your answer will be, because I think our points of difference are clear, but I have to put the point that when you look at this figure, you can see the Crystal Rig turbines, and yes, they're below the horizon, I know, but you can see parts of them. But when you actually look at the horizon there, that horizon is not designated.
Can I just ask which figure you're looking at?
817S5.
S5 only shows the proposed turbines,
It's got Crystal Rig turbines on it.
just the proposed Crystal Rig 4 turbines?
Yes? Yeah.
Yes. But you're talking about the Aiken-Gould turbines?
No, I'm talking about Crystal Rig turbines. when you look at those turbines, yes, they're beyond the horizon, they're Crystal Rig 4, but my point is that when you look at the horizon, the black line, the horizon, that is undesignated Dunbar Common, not designated SLA.
No, I'd have to disagree because the Dunbar Common is beyond the horizon line. The horizon is within the special landscape areas.
It's the answer I expected, but I had to ask the question and get the answer. So look at viewpoint 18, please, as well. Now, viewpoint 18, we can see from JW1, we can locate it. That is right on the edge of Dunbar Common, isn't it?
Yes, it is.
And therefore in an undesignated area, correct? That's not part, the viewpoint's not within the SLA, is it?
The viewpoint's shown on the boundary, so it's hard to say whether it was in or out, but I would say it is looking out. It's not looking at the special landscape area when it's looking south.
Yeah, all right. Well, we say the viewpoint is outside. The reporter has a note of that evidence. I'm not sure we can resolve this factual difference very easily, but I want to come back to one further point on this issue, because it may or may not be of policy importance. The reporters have to decide what guidance applies to which area, and that's why I'm pursuing this with you, that the only reason, I just want to get it clear, for omitting the Dunbar Bowl, as you call it, Dunbar Common, from SLA designation when it was an AGLV before, is, first of all, you didn't know why it was an AGLV, although I follow that as far as it goes, but the most important point is that the character of that area had changed. Is that right?
The character of that area wasn't defined as being special enough to allocate as a special landscape area. All right.
I think I know it's unsatisfactory, reporters, but I have to leave that question of fact there. I can't take it any further. Go to, and that's not blaming you, we have the information we have. Paragraph 2.5 of your precognition, please. You say in 2.5, it should be noted that although the proposed light beam is narrow when limited to the height of a room, you refer to Mr. Welch's figure taken inside the SNH's offices, that photograph. At 5 km, the 4-degree angle beam will be 349 metres wide. 20 km, it will be 1.4 kilometres wide. This is a wide area over which the light will spread in East Lothian, as shown on JW1. We don't question your mathematics, so just make a note of that. They're correct. But as put by Professor Lumsden yesterday, what we're looking at there is the vertical spread, isn't it? The vertical spread of the beam?
Yes.
So from essentially minus 1 degree, in other words, 1 degree below horizontal, to 3 degrees above horizontal.
Yes.
But I'm not quite sure where your point goes, because the ZTV shows what it shows. You're not saying in any way that actually the effect is greater than shown on the ZTV.
I'm not. I'm just saying that that is what it shows on the ZTV.
Probably we're taking your point further than it was intended to go then. Thank you very much. If you go to 4.3 of your precognition, please. And also, because I'm looking at the first sentence, this is ELC 18. You might just get out ELC 18 if you would. Now, you heard what Professor Lumsden said about that image, that it's a satellite image looking through cloud, and he explained that's why you get a smudging, a smearing, whatever you want to call it, of the visible light. Do you remember that?
Yes, I would refer, there's 2 maps in that document.
Sorry, the first map.
I make reference to both maps.
Sorry?
I make reference to both maps under ELC 18. I'm not just referring to the first map.
We're looking at the first map now. Looking at which says dark skies in East Lothian. The other map, I'm actually quite uninterested in. It's such a small scale, it doesn't really help us. But the first map, to which Professor Lumsden referred, you remember what he said about the fact this is obviously taken through cloud, and he explained that means that you're looking at a smudging of light. In fact, the lighter areas appear lighter than they would be, or the light is more spread because of the effect of cloud. But on the other hand, you may miss some of the smaller light sources because of the cloud. Do you have any reason to disagree with what he says?
No, I don't.
Thank you. If you go to paragraph 4.3 of your precognition, again, about 2 sentences on, the skyline is visible on moonlit nights, and the darkness of the hills has a different quality to the sky at night time on non-moonlit nights when the matte of the hills contrasts with the starlit sky. And then you refer to his photographs and say these photographs show the dark linear band of the hills. And you remember I went into these photographs with Dr. Lumsden.
Yes.
And perhaps because it's unfair to put very technical points to you, which I don't understand myself, but put it this way. Let's get out D5 actually, his image, it may be easier. It's Dr. Lumsden's image D5 from within CD 10.4. Do you remember that he spoke about atmospheric attenuation, a scattering of starlight, the creation of what he called a milky band across the horizon?
Yes.
All I want to suggest to you is that when you look at the image with you look at this view with the human eye, you don't actually see in these conditions the dark band of the skyline. There is a contrast, but it's a contrast between whatever you see of the ground below and its lights, and then it fades into the sky, but you can't see in these light conditions with the human eye that dark band.
What I'm trying to show is the distinction between the lit foreground of the plain and the darkness of the hills, and then you see the sky, the moonlit sky above, or the starlit sky above. So there is, I do think you can see the distinction between them.
Perhaps it's the phrase dark linear band that I'm questioning with you. I don't dispute that you will see a difference in colouring. We say it's probably more gradual. It's not a dark linear band you see in these light conditions. That's my suggestion. Of importance, because I'm talking about seeing the land form.
Yes, I think there's a difference in characteristics, though, because you don't see any stars within that, so it does appear as a dark linear band. Because it is a band that runs right across East Lothian and views from the plain where there are no stars.
All right, I've got your evidence. The difference between us is you see it as more of a band. We see a more gradual fading from the land to the sky. Fair enough. That's okay. I mean, all this is visual evidence, and the reporters can take the difference of opinion into the field and make up their own minds. That's fine. It's difficult to take this technical evidence much further, but I'll just try you on one point, that you remember what Professor Lumsden said yesterday, and this is an enduring debate, believe me, in the representation of wind farms and visualizations, the difference between what the human eye captures and the camera captures. And perhaps what we're learning now is that the position at night may be a little different to photography during the day, that actually the eye cannot resolve as well as the camera at night. Is that your experience in the field?
Yes, I don't think you can rely on photographs. I think you need to go out and experience it. And anything that we've put forward is just as a representation of, it's not an actual image of what you would see. It just gives the idea that there would be lights or there wouldn't be lights.
That's very fair, but of course the reporters will go back to base and they will write their reports having seen what they've seen, but they will be making reference to the images before them. Inevitably, would it be fair to invite them to be cautious about the use of the images in the sense that at night the human eye cannot resolve as well as the camera? You've got to be cautious in the use of the images.
I think the evidence from Dr. Lumsden was that the human eye resolves more than can be shown in the camera. It's far more sensitive.
No, it wasn't actually. The evidence he gave was that because the eye does not view matters in the linear way that a camera does, you leave a camera there, and over the exposure time it will capture what there is to be captured in a way the human eye cannot. So actually he said no, the human eye cannot resolve as well as the camera in nighttime conditions. I want to know if you would agree with that, and so we should invite the reporters to be careful in the use of images when back at base.
Yes, no, I would agree with that. We've put forward our images as just as representations of.
Sticking with Professor Lumsden's images, if we could go to D1, which is, you mentioned in 4.3, which your paragraph 4.3, which is why I take you there. This is the White Kirk image, a series of images, and he explained what he'd done in each of them. You remember that?
Yes.
And perhaps what I'm suggesting to you, that insofar as you can see any linear band, any line of the hills, and you can quite clearly see the line of the hills there, that's because of the effect of light pollution. Were it not for the light at this time of day, you would not see that linear band. It's the effect of pollution which gives the visibility.
But this is an example of the view that we get at night. So the light pollution allows you to see that linear band.
Absolutely. It may in turn prevent you from seeing the red light, but that wasn't the point I was making, that what you see of the landscape at night in this image is due to the pollution present, the light pollution present.
In this specific image?
Yeah.
Yes.
And that would also inhibit your ability to see the red light to some extent. In your experience from going to White Kirk?
No, because the red light sits up above the plane, so up above the lights that were in the plane. The experience I had from visiting the site wasn't quite like this picture at all. I didn't have the light pollution reflecting off the clouds in the same way. As I think that comes back to the point about photographs being quite different to the way the light, your eye interprets it, the view.
Okay, well, we know that images D2 and D3 have been manipulated, so we can ignore those. But looking at D1, that's the image which, subject to what the human eye can resolve, that point, which we've already explored, that is, we say, what the reporters will see when they go to White Kirk. That has not been manipulated.
That's what Dr. Lumsden said was closest to what the eye would see.
Yeah. He did? You're quite right. He said exactly that in his evidence in chief. That's as closest to what the eye will see. So we can leave that with the reporters to resolve when they go out on site. And looking at D7B, finally in this series, perhaps the point I want to put to you here, this is sunset plus 35. So the light's been on for 5 minutes. It's the end of civil twilight. You remember those, the gory detail from yesterday about twilight. And I think he would say, look, you're not saying you can't see the light in these conditions, but the amount of light present in the sky makes it quite difficult. Would you agree with that?
I would agree, and I would agree when I was on site at this time, it was very difficult to see the light until it got slightly darker.
That's fine.
But I would point out that it's just a single light that's up there, and in some of the views there's going to be a group of lights which might make it stand out more.
Well, actually, to aid the reporters on their site visit, this is Whitekirk, of course.
Mm-hmm.
And we can go to the viewpoint, go back to the evidence on Mr. Welch yesterday if you want. You remember he said that at viewpoint 19, with the 4-light scheme, you would only see one light. And actually at Whitekirk, you would probably only see one light.
JW1 shows just one light, and the ZTV. At Whitekirk, at viewpoint 19, it suggests theoretical visibility of 2 lights. Yet the visualization that was produced would suggest that only one light was visible. So there's something different between those two. So one of them wouldn't appear to be correct.
Well, it's a pity that wasn't explored with Mr. Welch yesterday. So I'm hearing that for the first time. Happy to recall Mr. Welch if anyone wants to deal with that point. But if you go to the wireline, we needn't go there. We went there yesterday. We can see that he confirmed, in fact, that only the one light would be visible.
From the wireline that's been produced, only one turbine.
Yes, from viewpoint 19.
Visible, yeah.
And he also mentioned that there was some vegetation around that skyline which might even preclude that view. But we're not claiming that. It's for the reporters to look at. But in terms of Whitekirk, his evidence was clear that you would only see one light from Whitekirk. I'm making this point because of the site visit.
Yes, that's right. For that site visit, there will only be one from that viewpoint. But
Right.
I think that JW1 shows that there'll be visibility of up to 4 hubs around that area.
Yes, but
in
don't
other parts
forget
of the area.
that when it says up to 4, it's between 1 and 4, so it could be 1.
No, there are areas where it shows that there will be 4.
I see. So are you talking about viewpoint 19?
No, I'm talking about generally within this area.
Oh, no,
Because
please.
viewpoint 19 is a specific viewpoint, but it's only representative of the area.
Yeah,
So
I'm
within
not-
the wider area, there will be visibility of more than one.
I'm talking about the viewpoints to which the reporters will go on a site visit. No doubt, if you go further to the east, you'll get some blue and some green shading. But at viewpoint 19, I don't think we're in dispute. You'll see one light, and I'm not sure you're arguing that at Whitekirk you will see more than one light.
No, at Whitekirk, you'll see, according to the ZTV, you'll see the one.
Okay, that's fine. And I'm not disputing, to save any re-examination, that if you go further to the west from Whitekirk or from viewpoint 19, you may see more than one. That's fine. Can you get this out of the way? Thank you. If you go to 5.3 in your precognition, this is where in the last sentence you talk about commuters, so that's what I want to focus on. You heard the evidence yesterday from Professor Lumsden about dark adaptation. Do you remember?
I do.
And how the human eye adapts to darkness. It takes some time. How much time depends on the individual. And the perhaps slightly counterintuitive point that if you're totally dark adapted, you may not see a red light, when if you were half adapted, you might. It all gets very complex. But just a couple of points to put to you on this topic, that in the circumstances you described, commuters will be driving with the headlights on.
They would.
And those headlights will, to some degree, how much I don't know, affect dark adaptation.
They will.
And any commuter, so unless he's in a traffic jam, is going to be moving at a variety of speeds. It's as a transient experience.
It's transient, but it's the perception of it. Once you've seen a light, You have that perception in your head that there is something there.
Okay. But that, the driver, if there's a passenger, not so much, but the driver should be focusing on the road.
You focus on the road, but you see other things around about you.
Yeah, okay. But if it's in your peripheral vision or off to one side, you're much less likely to capture it than if it's ahead of you if you're driving.
Yes.
Fair enough. And if a car does come the other way on any of these roads, which may well happen during commuting hours, then your dark adaptation is, if not destroyed and has to rebuild itself, is badly affected.
Yes, I would agree.
And in those circumstances, you're less likely to pick up any red lights at all, at least until you're dark adapted again, by which time you've driven on. We
yes,
agree that.
If it happens at that point, at that exact point where you're viewing the lights, yes, you lose that.
I don't think we're in disagreement about a lot of this, but
Yeah.
it's good to get that out. If you go to 7.1 in your precognition. No, we dealt with that. I'm not setting this cheap one, really. A lot of this. Yes, 4.2, paragraph 4.2 in your precognition. I'm just intrigued in your second line. You say the importance of the landscape character of East Lothian at not only a national but also regional and national level. I wondered what you meant, importance of the landscape character at a national level.
I think I was referring to the Southern Upland Fault.
Oh, I see.
And the start of the landscape character assessment, where we notice some characteristics that are of regional and national importance.
But in a planning inquiry, we're concerned with the planning designations when we talk about national level. You're not claiming of any national level of protection for any part of this landscape?
No.
Thank you. Coming on to landscape impact, where you and Mr. Welch are in disagreement. He says, look, this is primarily a visual effect. You really cannot discern the features in the landscape clearly enough to make any sensible landscape impact assessment at the times of day and night that we're talking about. You disagree. I'm not going to try and persuade you to change your view, but I want just to explore your view of it. Go to paragraph 4.3, if you would, on paragraph 4.3. And I'm looking at the second half of that paragraph, where you say, having referred to Professor Lumsden's photographs, I therefore disagree with Mr. Welch's statement that loss of important features and composition of the view are not readily discernible at night. And you go on to say in the last sentence, the impact is on landscape character and loss of distinctiveness, not just on views of the night sky. You do look again, if you want, at, say, figure D5 or whatever you want to look at, but I'm looking at D5. I'm finding this a little hard to follow, noting that we are now the human eye and not the camera. What important features of the landscape could be lost or affected as a result of these red lights?
It's been described as a dark landscape. The hills are the defining feature, they're distinctive. Introducing lighting to that loses that landscape feature and the distinctiveness of that landscape character.
Perhaps it's a matter of words. By feature, all right, perhaps we had in mind more physical features. Composition of the view. I mean, there is no view other than the light at night. You cannot see the landscape. How is it possible to lose the composition of the view?
Because the view is defined by the lit lowlands and the dark line of the unlit hills. So you still have that perception of the landscape character, even at night time. introducing lighting into that takes away from that distinctiveness and therefore the composition of the view.
Microphone.
Let's turn to a document that I didn't think we'd have to go to, but we do, is the GLVIA, which is CD 58, sorry. If you go to page 157,
Sorry, what page was that?
page 157. It's the glossary.
In 5.8.
5.8. It is 5.8, isn't it?
That's the visual representation of wind farms.
Oh, God. 5.7, sorry.
Right.
On page 157, we have certain definitions used for the purposes of this document. And landscape character, a distinct, recognisable, consistent pattern of elements in the landscape that make one landscape different from another rather than better or worse. And then 2 down, landscape character assessment, the process of identifying and describing variation in the character of the landscape and using this information to assist in managing change in the landscape, seeks to identify and explain the unique combination of elements and features that make landscape distinctive. I really do question whether you're looking at landscape character issues when you described what you've just described about the impact of the lights. I would suggest to you that you really are looking simply at visual effects in this case, not landscape character effects, because it's quite impossible to perceive the distinct, recognisable, consistent pattern of elements on the landscape when looking at this at night.
I would have to disagree. The landscape character of the uplands is defined as a dark landscape. It's one of its defining features. And that's recognisable at night because you've got the contrast between the lit plain and that's still that dark band of the landscape hills, and you're introducing light into that. It affects its distinctiveness.
Have you carried out a landscape character assessment at night?
Only in terms of this.
And when we look at the CD 413 or indeed any landscape character assessment, what we see in the product of that assessment is a product of daytime assessment, isn't it? Not nighttime assessment.
Yes.
Yes.
I think this is a new area we're going into with the aviation lighting.
Lord help us. I do suggest that this is over-rigging it, that what we're looking at here is purely a visual effect, that it is simply not possible to discern the pattern of elements in the landscape that make one landscape different from another. I'm quoting from the GRVIA at night. It can't be done.
But I think it is done in East Lothian because you have the lit plain and you have the dark hills.
Five 3 in your inquiry report again, but the first part of it this time, where you refer to ELC 11, discusses 2 of the viewpoints within the hills from East Lothian, etc. Now, those, I don't think we need to go to ELC 11. I've been there, and you're talking about viewpoints 9 and 13. Those are the 2 you talk about there.
Yep.
By all means, go there if you want. I'm not stopping you, but I don't think you need to. If you go to JW1 again, the amended version of JW1, I just want to trace a line on a map for the benefit of the reporter's site visit and make some suggestions. But if you look at the road that goes from Preston, it's the B6355, it goes all the way up to viewpoint 13. Yep.
Yes.
The visibility along that road is, as you move west from Preston, you get to the area of viewpoint 4. I suggest there's no visibility on the road itself there. There is some potential visibility. What's blue? Let's remind ourselves of 4 turbines just north. But then coming into the area closer, as you come up by Cranshaws, you've got a lot of trees there, haven't you, that would probably prevent views?
That's more within the borders area. It's not an area I've made assessment of.
No, that's right. I'm not one for boundaries in that sense. If you can help us, help us. If not,
Yeah,
don't.
it's not an area that I know well.
You haven't. All right, well, let's go to the border in that case. Into East Lothian, no visibility whatsoever until you get very close to viewpoint 13. That's correct, isn't it?
That's correct.
And then once you get past viewpoint 13, again, there's nothing at all.
Not on the road, no.
So, all right, if you want to stick to East Lothian, looking at East Lothian, the only visibility you get from that road is at and around viewpoint 13, correct?
On the B6355,
Yep.
yes. Yep.
And if you look at viewpoint 9, which is on the minor road coming up from Longfamacus, coming northwest, okay, let's start at the boundary of East Lothian and Borders, where it goes in and out a bit. I'd suggest there's absolutely no visibility until you get to viewpoint 9.
There's some visibility to the south of viewpoint 9. I think there's a couple of 3 turbines, 2 turbines.
Approaching viewpoint 9 then,
Yep.
and viewpoint 9,
Yes.
and for a bit beyond, and
Yep.
then you reach the junction with the B6355.
Yes.
So can we agree that within East Lothian, any concerns which might lead to an objection based on views from these roads would be rather over-egging it, the extremely limited visibility along these roads?
There's a small area of visibility in the hills around those, but it still changes the landscape character of the area and the loss of distinctiveness by introducing lighting into that view. And I go back to my comments about perception. Once you've seen a light, it stays in your mind that you know there's a light there, and it changes your perception of the character.
Well, hang on, this is getting into dangerous territory. If you're telling us that an impact arises not just when you see something, but because of your memory of what you have seen, you're going to a very different area.
Well, I think that's the case. I don't think you forget things, and it could well change your perception of the character.
Sorry to say, but oh, come on. If you are driving, any driving experience, you retain a memory of what you've seen, but are you really trying to factor that into landscape impact assessment? The fact you get home and think, I saw a light, it affected my image of the landscape, and therefore that is an impact I will assess? You're not really saying that, are you?
I say it could change your perception of the character. So yes. Yes. I think it would change how you view the landscape, and then maybe how you would use the landscape in future.
I may say so, that it's a bit of an extraordinary claim, that I can understand that as you drive past, say, viewpoints 9 and 13, or indeed past any viewpoint where you get a view of any proposed development, well, let's stick to this one, 4 red lights in the sky, you will retain a memory of what you've seen. But what we're looking at here is viewpoint assessment from the person at the position at the time. That's correct, isn't it?
Yes.
Yes. That's what the GLVIA tells us.
Yes.
There's no advice in the GLVIA to somehow factor in post-experience impact.
No, it's also, from a specific viewpoint, it's supposed to be representative of a wider area.
I've reserved actually most of my questions for Catherine Andrews, being the board as witness. That's my cross-examination. Thank you very much.
There's no questions from the reporters. Mr. Campbell.
Thank you. Just briefly, Mrs. Jane, you were asked about Dunbar Common and it not being designated as an SLA. And the reasons you gave, can you just remind us, I think there were two reasons why, just to clarify what the reasons were for Dunbar Common not being designated as an SLA?
It's landscape character, as well as the presence of the turbines.
And in the context of the landscape character, did you consider the impact of darkness?
That wasn't a defining determination.
Well, for designating an SLE in general, is darkness a criteria that's considered?
Yes, it is.
You were also referred to Dr. Lumsden's evidence and the mapping exercise. Dr. Lumsden's evidence was that the mapping was milky and smudged, and that the photograph must be taken in cloud. Can I ask you, from your experience of living and working in East Lothian, would you agree that there's a significant difference in the light between the East Lothian plain and the Lowermuirs, as
Yes.
shown in that map?
Yes, there is.
That's all. Thank you.
Okay, thank you. Ms. Jane. I suggest we perhaps take a 15-minute break and then we can perhaps start on the planning policy and energy hearing session. Is that okay with everybody?
We've got a lot of shifting around to do. Could you give us 20 minutes?
Done.
Thank you.
People are happy to start? Okay. Just two things to say about the agenda before we start. First is that the agenda hasn't changed, but you may have a copy that says draft on it. Apologies if that went out with the watermark unremoved, so apologies for that. And also, the omission of a critical word in the towards the end of the little note in italics at the beginning. I say no other matters shall be discussed and no direct cross-examination of parties will not be allowed. So apologies for missing out the critical word not. Okay. Right, the procedure for this hearing session is that I will lead a discussion based on the points listed on the agenda. There's no need to read out your statements, but as we go through the points on the agenda, that should enable you to put your point of view and give Ms Haywood and myself the information that we require. As I say, there will be no cross-examination, but you can ask questions of each other if you don't understand something that someone says. Please remember that we have to take a note of the discussion, so we may have to ask you to slow down at certain points. And I'm sure you'll be very polite to each other, but could ask you not to speak over each other and use the microphones when you speak. Thank you. I can see there's a few people who are no longer here, and there's an addition of a new person at the table. So, Mr. Trinick, could I ask you to introduce your team, please?
Thanks. So the team will be led for the session by David Bell, who sits to my left, who provided the policy hearing statement for the applicant, I will take part, but not very much, and Mr. Gillis may take part, depending. Thank you.
Okay, thank you. And Scottish Borders Council, see you, the two of you there.
Yeah, it's similar. Like Mr. Shear, the lead role, and I will chip in where I feel appropriate.
And East Lothian, Mr. Kirk gave his apologies. So sorry, Mr. Campbell gave his apologies. Yeah. So.
Hello, it's me. I'm still Jean Squires. I'll try and answer if I can.
Okay. Well, thank you very much for. I was just going to mention that you'll be aware that we have received a written submission from Mr. Kelly on behalf of the Mayshiel and Cranshaw's estate, which also includes a commentary on energy and planning policy matters. And I'm aware that when we had the pre-inquiry meeting, Mr. Trinick, you did say you would provide a response to the written submissions that we had received, but I can't recall receiving something from you regarding Mr. Kelly's response.
Communicated that we would deal with any response in the hearing session.
Okay.
There's no written response.
Okay. Well, thank you for that clarification. Right. You'll see from the agenda, I've kept very broad headings, and I'd like to work our way through. Starting with renewable energy policy, then moving on to national policy and guidance, and then we can, towards the end, perhaps focus on the development plan. I've intentionally kept the headings quite broad to enable us to have a fairly wide-ranging discussion, saying to give you opportunity to bring to our attention matters you think are important, and saying in that regard we've received these two documents this morning. I was perhaps going to ask Mr. Bell to start, and could I ask you if there's anything in particular that you'd wish to draw our attention to in your summary of international and European policy considerations. You note at 2.211, which is the European policy and targets, that 15% of all energy consumed in the UK is required to come from renewable sources by 2020, and that the position at the end of 2018 was that renewable energy only accounted for approximately 11% of energy consumption. And I was wondering if there's any indication whether or not that target will be met once the data from the past 2 years becomes available. So is the UK's position likely to be better or worse than that expressed in your statement?
Probably be better than that. We don't have the data yet, though.
What is the lag? I mean, how soon will we have that information?
That information comes through the digest of UK energy statistics, which becomes available in July each year, and it's been very consistently available in those months. There may be some preliminary information that comes through BASE in earlier months, and it's usually highlighted as preliminary before the full data is analysed. The key point is that there remains a shortfall against that legal obligation.
Other than that, is there anything else you'd like to add under that general heading of European policy considerations?
Just maybe to put that statistic in context, because the key point at 2.2.9 in my hearing statement is that the directive that's in play at the moment is the revised Renewable Energy Directive of 2018. For many years we were dealing with the 2009 directive, but the directive entered force in December 2018, and that has a target for the European Union 2030 for 32% of energy to come from renewables. And I do refer at paragraph 2210 in my hearing statement to the European Union Withdrawal Bill, but of course that is now in Act, and the European Union Withdrawal Agreement Act 2020 received royal assent on 23rd of January this year, and that converts all EU law, rules and targets into domestic UK governance, and therefore that obligation is carried forward through the transition period. And the directive makes it clear that the national target set for 2020, and that's that 15% figure so that you refer to, will be the minimum member states' contributions to the 2030 framework, and that's the 32% target. And I think the last point to say is at the moment there's no evidence to indicate that the UK will move away from that target at the end of the transition period.
Okay, thank you. Borders Council, East Lothian Council, do you have comments to make under this heading? Perhaps starting with Borders.
No, I don't think we have anything further to add to those comments that we've just heard.
East Lothian?
Yeah, I'd agree. That sounds like reasonable.
Okay, turning to the next item on the agenda is about UK energy policy. And I prepared these notes before you lodged these documents. So, Mr. Bell, your statement was prepared before the UK government's decision to allow onshore wind projects to compete for subsidies alongside other forms of renewable energy developments was announced last week or the week before, perhaps. In light of that announcement, is there anything that you would like to add to your statement? In particular, I'd be keen to hear how this might change the policy context in Scotland as much as what was reported within the context of England and Wales.
Right. In terms of the government's position on contracts for difference, I do think it's important to have a look at the document. There's a few references I'd like to go to, taking it fairly briefly within that. But before delving into that specific document, I think it would be helpful just to set the scene briefly in terms of net zero and how this document relates to that policy position. There's an important thread that ties it together that then allows us to see where the Scottish Government is on that as well.
Okay, that'd be helpful. Thank you.
And I'll try and take it fairly quickly. I think, firstly, energy policy is a reserved matter to Westminster, but it's clear the Scottish Government has been progressing its own policy on energy, climate change and planning, and the three tie together. The foundation of a lot of the current UK and Scottish policy stems from the Paris Agreement of 2015, and in turn that led to the Committee on Climate Change looking at what policy direction the UK should take to achieve the commitments made under the Paris Agreement. And I think 2019 in many respects was quite a landmark year. We saw the school strikes starting, we saw Extinction Rebellion, Greta Thunberg raising a lot of profile. And we saw statements of climate emergency being made by national government, and that was in the Houses of Parliament on 1st of May 2019, and also from the Scottish Government. And I've set out that in the hearing statement. And the UK Government acted on the CCC Committee on Climate Change Net Zero report, which we've referred to as CD 7.19, which made it clear that a net zero target for 2050 for the UK would deliver on the UK's commitment of signing the Paris Agreement. And the then Prime Minister, Theresa May, sought to amend the Climate Change Act 2008 to bring net zero into UK law for 2050. And I refer to that at my paragraph 2319. Now, turning to your specific question on the CFD consultation document, now that's the scheme that incentivises investment in low-carbon electricity generation. And that was issued following calls at the end of last year for a review of renewables policy, the renewables policy framework in light of net zero. And as you say, at the beginning of this month, the Secretary of State, Alok Sharma, the Minister for Base, confirmed that onshore wind and solar developments would be able to bid in the 2021 CFD round. The consultation document, which is CD 7.30, is a consultation on how best to facilitate that change. So it's not whether or not onshore wind should be able to compete, it's simply about how it should, how the mechanism should facilitate that. And it's important to recognise that is a change to the position that the 2015 government brought in, which was basically blocking onshore wind from the ability to bid for a price guarantee. It was entirely embargoed. And at the same time, that was when there was an effective veto given to local communities for onshore wind projects in England. And that effective veto is still in place by way of national planning policy in England. So if we turn to the document itself, and that's CD 7.30, and this is helpful in terms of understanding the UK policy position as it is at the moment. On page 10, which is the introduction, if people have that, it states, we are considering changes to ensure the CFD scheme is able to support the increase in ambition needed to deliver the government's 2050 net zero target. And it goes on in the middle of that page to state that the net zero target, which came into force 27 June 2019, as I say, that was by way of amending the Climate Change Act in England and for the UK, states that it will require to the UK to reduce all greenhouse gas emissions to net zero by 2050. This is a landmark decision for the UK and one which demonstrates we are continuing to lead the international effort. It goes on to state that whilst we cannot predict today exactly what the generating mix will look like in 2050, we can be confident that renewables will play a key role alongside firm or flexible low-carbon generating capacity. It goes on at top of page 11, first paragraph. The UK's new 2050 net zero emissions target means we will continue to require substantial amounts of new low-carbon power sources to be built before 2050. Committee on Climate Change advises the UK could require 4 times the amount of renewable generation from today's levels. requiring sustained and increased deployment between now and 2050. And then in the next paragraph, it says the CFD allocation rounds can best support an increase in the pace of renewable deployment needed to achieve net zero ambitions. And just on page 12, third paragraph, there's a reference where it states, as well as working with the sector to deliver offshore wind by 2030, it's likely that higher levels of wind deployment will be needed to help the UK achieve its 2050 net zero target. And if we go on to page 15, again there's a reference to the CCC. It says, Committee on Climate Change believes almost complete decarbonisation can be achieved, but to achieve this, low-carbon electricity generation will need to quadruple by 2050. And then lastly, on page 16, it states, we are aware of a number of projects, mainly solar PV and onshore wind, that have deployed or are planning to deploy on a merchant basis since the last Pot 1 auction was held, so they're aware of some merchant schemes coming forward. But they go on to say, and this is the important point, however, there's a risk that if we are to rely on merchant deployment of these technologies alone at this point in time, we may not see the rate and scale of new projects needed in the near term to support decarbonisation of the power sector and meet the net zero commitment at low cost. So what was happening was, because onshore wind and solar was blocked from CFD, there was a cliff fall in the number of projects coming forward that could be built. And we know there's a lot of consented capacity. That's clear from the government statistics. But what's also clear is that projects were not coming forward to implementation because they were either having to go for tip height increases by way of many Section 42 applications or Section 36C variations to get higher turbines to be able to operate on a merchant basis, or they were simply not coming forward at all to implementation. So with the CFD now being open to onshore wind, that will allow a quantum to come forward to have that price guarantee.
Perhaps you could just explain what you mean by merchant. I mean, your maintenance here.
Well, that would be operating without a subsidy basis, so relying on the wholesale market price for electricity without a stabilisation mechanism like CFD. So it would be building a wind farm and relying on wholesale prices in the market only. Now, some developers might have a power purchase agreement with a party to purchase electricity at a specific price, but these are few and far between. I think there's one being built in Scotland on that basis, and that's Inverclyde at the moment. I think there was one in England last year that was built out on that basis that had been consented before national planning policy was changed. Whereas the CFD mechanism will provide predictability for revenue streams, and it would enable, under the CFD arrangement, there can be payments from government to a generator and from a generator to government. There's a stabilisation mechanism in there that allows price certainty for the electricity. So that would enable many more projects to come forward should they be awarded CFD.
And there are a number of consents already in the schemes that have got consent that could come forward under this new consultation. That's right. Yep. This is just a consultation, though, isn't it?
It's consultation on the mechanism, but the decision to allow onshore wind and solar, my understanding is that that's been made in the statement by the Secretary of State. So the technologies will be allowed to bid, and the consultation is on amendments to the scheme.
Do either of the councils have a comment to make on this matter?
No, no comment from Scottish Borders Council on this.
I haven't had a chance to really read the document and think about it, but I think if the contract for difference is coming in for onshore wind, presumably that would help make the scheme more viable, perhaps even at a lower height, which might not require aviation lighting.
Any thoughts on that particular point, Mr. Bell?
Well, I think the CFD is a finite amount that goes into the pot 1 next year. And this scheme has been designed such that it doesn't require CFD. So there's a risk in going for CFD that one simply doesn't get it. One doesn't get the right strike price when bidding. So we're fortunate in that this is a scheme that is viable on a merchant basis without that. And that is how it has come forward.
That was the point I was asking yesterday, Mr. Welsh, anticipating that you'd answer me on why the turbines were so high.
I've got more that I'll be able to cover in any other business at the end, just to give you the references to where that information is.
Okay, thank you.
There is just one final point on UK policy. It's the Heathrow decision and how that should
hear from you. Yes,
should be considered. It's, I think, CD 9.34, Court of Appeal judgment, 27 February 2020, and it's lengthy, but I'll give you some paragraph references. It relates to the legality of the government's policy in favour of the third runway at Heathrow, and it relates in a large part to Section 5 of the Planning Act in England, and Section 5 of the Planning Act required the airport's policy statement to include reasons for the policy, including how it had taken into account government policy relating to mitigation of and adaptation to climate change. And in short, the judgment held that the Paris Agreement constituted government policy and ought to have taken into account that policy and to explain how that had been done. The key point is that it is useful in emphasising the importance of climate change requirements and does confirm that these requirements form government policy. And I would say that key references for you would be paragraph 221, which is actually 222, where if you have it there, you can see that there was reference to Mr. Crossland submitting that the government's commitment to the Paris Agreement was part of government policy. And the judges state, Mr. Crossland's position was supported. In our view, that submission is well-founded. And paragraph 224 states, it is important to appreciate that the words government policy are words of the ordinary English language. And then at 228, in our view, as the three judges, government's commitment to the Paris Agreement was clearly part of government policy. This followed from the solemn act of the UK's ratification of the Paris Agreement. And then paragraph 283 refers again to what's referred to as the government's firm policy commitments on climate change under the Paris Agreement. So, insofar as the Paris Agreement is referred to in my hearing statement as part of government policy, we say it's firmly government policy. that links to the Committee on Climate Change, what they were asked to look at, identifying net zero, and in turn the new law set by the UK Government on net zero, and in turn will come to the Scottish Government's position. So one can see the thread carried through from the Paris Agreement, and the Court of Appeal has given us clarity, if there was any doubt, on that forming part of government policy.
Okay, thank you for that. Before we do move on to Scottish Government policy, does the councils have a view on this?
I had the opportunity to read through the Heathrow decision so far, so I don't have any comments directly in response to that. Just an observation, maybe more than anything, and it was something that Ms Squires picked up on as well, was that the reference at the Gilston wind farm decision, where the point about wider energy policy was considered. However, in determining that application, it wasn't found in favour of that presumption for the development. So, yeah, like I say, just an observation to respond to that point.
Ms Squires.
Likewise, I haven't had a lot of chance to read the whole thing, but as I understand it, the judgment was that they had erred in not taking the Paris Agreement into account, not erred in saying that that was that the Paris Agreement was overriding, and they should therefore have made a different decision. I think the judgment was on the process, not on the actual decision itself. Also on the actual decision itself, I suppose it was taken over an issue which would be expected to increase emissions quite considerably for the UK as a whole. So it's not in the same league as one that would maybe reduce emissions slightly. So I'd say it's a far more impactful decision. Is the one is what I mean by that.
Ms Bell, your response to what we've heard?
Just to say briefly, in terms of Gilston, it's a fair point raised, and we will perhaps deal with that at the end of the national planning policy section, rather than just now.
Okay, thank you. Okay, the next item was, following that thread through, was to Scottish Government energy policy. So, Mr Bell, if there's anything you'd like to add under that heading from what you said in your statement.
Thank you. I think it's set out in detail at 2.4 some of the more historic now renewable energy policy documents, and I go through in detail the Scottish Energy Strategy and the onshore wind policy statement. I don't think it's necessary to go through points in there. They're all set out. The more recent references are in relation to the climate emergency, which I refer to at 2.4.49 in terms of the First Minister's statements on that. And when that statement was made, the Climate Change Emissions Reduction Act was moving through Parliament, and that is now enacted, received royal assent on 31st October 2019. And at my paragraph 2461, I've set out the new targets there, which, when we come on to looking at SPP and NPF3, are clearly superseding the targets that are in those documents that date from 2014.
Thank you.
So that's really an overview on the most recent target position. What we are expecting is that there will be a new climate change plan issued at the end of April. which will deal specifically with the generation requirement needed to attain net zero and these targets. That's, if you like, the missing link in a number of the Scottish energy documents at the moment.
Sorry, so the end of April?
End of April, is my understanding. But the other reference point that we have is the Programme for Government, very recent document, September 2019, where it refers to the climate emergency, and I've addressed this at page 19 of my hearing statement, paragraph 2453, where the government is stating that we need to redouble our efforts, requires us to accelerate the work in relation to climate emergency and so on. And the programme commits the government to vital early action. So we're seeing similar language to what is in the CFD UK level document in terms of the scale of ambition, and refers back to the CCC's reference to quadrupling renewable capacity.
Again, do the councils have any comment on under this heading?
In our hearing statement, we obviously provided some observations there, but there's nothing said that I don't need to respond to.
Ms. Squires?
Yeah, obviously refer to the hearing statement as well. I suppose I recognise, as Mr Bell said, that there's been a lot of action this year about increasing awareness of the climate emergency, but nonetheless the science has been clear for quite a long time and has been taken into account through energy policy. But renewable energy targets have always been quite stretching, and credit to the renewable energy for mainly meeting them, in Scotland anyway. So it's to say that I suppose energy policy hasn't yet come out with the new targets, and the climate change strategy, which will come out in April, should make it clear what direction the Scottish Government wants to go in a coherent way.
Okay, thank you. Okay, moving on to item 3 on the agenda, that's the National Planning Policy and Guidance. Starting with the National Planning Framework 3, Mr Bell.
Yes, I deal with this in my hearing statement, page 19. Sorry, that's not right. Page 24, sorry, chapter 3, where I cover principally NPF3 and SPP. I think one important point on NPF3 is that the targets referred to at section 3.8, just to look at that. Are now pretty dated, where we see 30% of energy demand from renewables by 2020. That's now 50% by 2030. And there's no reference to net zero, the new legal position, either at the Scottish level or the UK level. What we do see at 3.9 is still reference to capitalising on the wind resource, but as I say, no reference to the climate emergency position. So to a large extent, very much behind the curve in terms of wider energy policy development that's taken place over the last 6 years, and in particular over the last year. And we know from the programme for government that the government's talking, that's CD 7.27, that there's a need for more radical planning policy options. They recognise planning as a vital tool in leveraging necessary change. SPP, I'm happy to go into that, sir, if you want me just to quickly refer to the position there, or do you want me to hold NPF3?
Perhaps hold, because I know that in their statements, particularly East Lothian Council, you've also pointed out or draw our attention to the fact that the MPF also recognises that renewable energy, whilst important, it also contains statements on environmental protection. So I was going to invite you perhaps to say a little bit about that.
I mean, as I've said in my hearing statement, there's strong support for both things. Really, it's carbon emissions. We want to reduce them. The natural heritage, we want to protect it, and it's always a balance of where those things, of how much harm you think there is to the natural heritage and how much benefit will come from the renewable energy. With this one, this isn't exactly the question. With this one, I also put something in my statement about air travel, because that's a third issue in this with this one. That was when we were under the impression that the aviation lighting was probably needed for the airplanes that come in to Edinburgh along that flight path, and not realising that actually they're going to be needed for one single helicopter. So probably could take a bit of that out of my hearing statement, because I don't know if that bit of MPF applies so much.
It's good to say on that all the references to air transport and international hubs and so on, I mean, the aviation obstacle lighting has nothing to do with air transportation. All air transportation flights will be on instrument flight rules, flying internationally over 30,000 feet, and on Edinburgh approach, coming over Musselburgh and so on, IFR rules there. So, all the references I would suggest in relation to that aspect in NPF3 are of no relevance. Fair to raise it. Yeah.
Mr Bell, yes, you mentioned Scottish planning policy. Perhaps now be appropriate time to give your thoughts on that.
As with NPF3, paragraph 154 refers to targets, and again, they largely replicate what's in NPF3, again, very dated. The legal position has simply moved on, as has energy policy, from what's set out at 154. What remains in place, of course, is the development management approach to onshore wind in terms of the spatial framework, and in particular paragraph 169, the various considerations, and also the presumption is in place and remains operational. There is one reference we were going to highlight at 170, which I think Mr Trinick is going to refer to in terms of SPP 170 and how that is referred to in the hearing statement, in particular of Scottish Borders Council. But in terms of SPP, those are the key points that I would highlight.
Before we hear from Mr Trinick, is there any comments that what you've heard so far or would like to contribute to the discussion from the councils?
Nothing so far.
East Lothian.
It's just to say that I agree, obviously, the legal situation has changed and the energy policy situation has changed, but I think it's the protection of the landscape is still in date, I would say, which is mentioned in both MPPF and SPP.
Okay, thank you. Yes, you may be coming on to County to discuss this point, but we were certainly keen to hear from you. Let's see now, on the... I think the statement of agreement between the parties acknowledges that in the context of an application for Section 36 consent and deemed planning permission, the statutory development plan is a material consideration in the determination of applications. Section 25 of the Act does not apply to the determination of such an application. So in that context, I was going to ask you, perhaps Mr Bell or Mr Trinick, how relevant SPP paragraph 32 is in our consideration of this application and in preparing our report for Scottish Ministers.
Yes, we've had a look at that, and I think before dealing with paragraph 32, the paragraph before that, that's of particular relevance, is 28 and 29, that introduces the presumption. So before getting to the development management action on 32-33, our position is that the presumption that SPP introduces in favour of development that contributes to sustainable development is a major underpinning principle in the planning system, and that applies to this proposed development, even though it's come forward under Electricity Act procedures. That would be our starting point. And similarly, in terms of paragraph 33, post 32 is fully accepted. There's no primacy of the development plan, so that is the case. Paragraph 33, that deals with the position where if policies are out of date or if a plan is dated over 5 years old, then the presumption is a significant material consideration. And there's a particular test that applies where you would get your consent unless the adverse effects significantly and demonstrably outweigh the benefits. So that was well rehearsed in the Kaplich decision, which was an inquiry report for the Electricity Act case, which I believe is lodged. And our position is that the presumption would apply, but clearly in these circumstances, the enhanced presumption or significant material consideration doesn't, because the development plan is, both development plans are reasonably up to date and not over 5 years old. I think that if one was to say that those provisions wouldn't apply to an Electricity Act case, I think it would be rather odd, because you would have a situation perhaps where one might have a 49 megawatt scheme where one could say, well, the presumption applies and the development benefits from that. But then a scheme of 51 megawatts wouldn't, even though they would have greater benefits for sustainability and helping to achieve the government's policy principle, paragraph 28. So our position is that in the framework of planning policy that applies, the presumption is engaged for the development, and it satisfies the guidance set out at paragraph 28 and 29 on that policy principle.
Any thoughts on that matter from Borders Council first?
It would be my understanding that what is referenced in SPP does apply to the consideration of this application. And as Mr. Bell has correctly said, our development plan is still within its proper time frame for it to form part of the material which the proposal should be considered against. Yeah, I think that would probably just leave on that point there.
Andy Slothian.
Well, our development plan has recently been adopted, and when Scottish ministers cleared it for adoption, they presumably took into account whether it met the terms of sustainable development, or they would not have let us adopt it. So I think if you view it as a whole, I think you would say that that would meet the criteria. Paragraph 4 of SPP says the system is supposed to be plan-led. That is our plan. So I would say the plan remains a significant material consideration. As to the change in energy policy, that has moved on a bit, clearly, in declaration of climate emergency, but again, I would say the underlying science is the same, and it's always been quite a big consideration in making plans.
So if I could just come and add something there.
Yes, please.
It's worth looking, I only pick on one decision, at CD 911, which is the Caplick report by David Bullier. And if you look at paragraphs, where does it start? 2.127 onwards, that is where he summarises his conclusion on the evidence in relation to the application of the presumption. I don't mean the application on the facts, I mean the application in principle. Because there was an argument, I was there, it was raised at the inquiry, that in particular paragraphs 32 and 33 were irrelevant to section 36 cases because of the reference to the primacy of the plan in paragraph 32. And the reporter, you will see, and I'll leave it for you to read, he clearly goes on to apply paragraphs 32 and 33 in that section 36 case. I'll leave you to read his reasoning. And I certainly agree with Mr. Bell that it would be utterly perverse for the advice there to apply only to TCPA cases, maybe at only a megawatt less than the section 36 case. Thank you.
There's just one final point to round off the SPP position.
Please do.
I think the point I would like to emphasise is that SPP and SPF3 date from 2014, and it's quite clear through the earlier part of the discussion at the start of the hearing that there's new legal provisions, new targets, and new policy pronouncements that have been made by, in particular, Scottish ministers. And my view would be reasonable to take the view that SPP and NPF3 is, to some extent, outdated, although not totally redundant, clearly. But they need to be viewed in terms of weight in that context. And one of the paragraphs that I set out in my hearing statement at 6.2.15 is that there does not need to be formal policy articulation in order to for matters to be given weight if they are material in a case. And that's where we start to get onto areas of law, and Mr. Trinick is going to expand on that point.
I will. Can I just first, before I lose it, deal with the SPP 170 point, before we lose that. In paragraph 210 of its hearing statement, Borders Council deals with SPP 170 and says, I'll just read it out because it's easier, SPP 170 refers to areas for wind farms being suitable for use in perpetuity. This is a significant change in policy, and that turbine sites must now be considered for permanent use, which makes it even more vital that extra scrutiny is given to wind farm proposals to ensure permanent damage to the landscape due to poor decision-making is prevented. I wouldn't quite put it like that. I think that's a bit mistaken, if I may respectfully say so. That what SPP 170 advises is that wind farms should be assessed in the development process as if they were permanent development. In other words, impacts that might otherwise, i.e. if it were not for the advice here, possibly be allowed because the development is temporary, should be evaluated as if the development was permanent. Frankly, there are no surprises in that particular advice, and most developers have taken that responsible approach. They haven't tried to plead the temporary nature of an impact to justify a development, but SPP has confirmed that position. What SPP does not say or mean is that the reversibility of wind farm development, if secured by an appropriate condition, is not material. The fact that the development must be removed, and therefore that most of the impacts are reversible, is indeed still material. And the weight that you give to that is a matter for you. So that's my position on SPP 170. Perhaps I'll pause there in case Mr. Shearer wants to tell me I'm completely wrong.
Mr. Shearer.
Thank you for that observation, Mr. Trinick, and I think you make a valid point, to be honest. Yeah, I mean, it is obviously clearly stated, paragraph 170 of SPP, that they should that wind farms should be considered for use in perpetuity, and I accept that it is common practice for there to be planning conditions on any wind farm consents for what should happen when a wind farm comes to the end of its operational lifetime. Obviously, we in the borders anyway, we're now starting to see some of our older wind farms coming towards the end of their operational lives, and yeah, there's from what we're hearing, there's going to be some considerations about the potential for continued use at those sites. So I think there is certainly a degree of thought that kind of should be taken into account when we are considering wind farms, that they may be around longer than what they were first thought of when the first wind farm was consented, maybe up to 25 years ago.
And I think it is fair, Mr. Trinick, I think you'll remember back in these days as well, that developers, when they first started doing these, made much more of the fact that they were supposedly temporary than they do now.
I'm not sure that's so. I think that if a developer sometime in the past or even now said it's temporary and therefore you have to put up with it for a short time, that would be wrong. I
agree with you, but I do recall developers saying that to me.
Well, they were wrong. But that doesn't mean that the reversibility of the development is not material. That's my point. But Mr. Bell asked me to come in on, but that little diversion was really, he wants me to be unpopular rather than himself, so it's my job. He's summarised fully in his hearing statement, has just summarised now the raft of new developments in law and policy that there has been since SPP and MPF. And I won't articulate them all, but there's, I counted 15 or 20, ranging from the Paris Agreement, IPPC, UN GAP report. But it's all in his hearing statement, running right through to the Scottish Programme for Government Declaration of Climate Emergency and the Climate Change Emission Reductions Targets Act. And then we have the Court of Appeal decision in the Heathrow. And in every forum such as this that Mr. Ballon and Mr. Gillis and I appear in, we say, look, these are very important pieces of new law and policy, and they must be taken seriously, and they must be given substantial weight as adding very significantly to the positive advice in SPP and MPF 2014. And too often, I'm afraid, in my view, reporters have taken a business-as-usual approach. And they've shown a reluctance to engage with or give weight to what has happened since 2014 until they see that SPP and MPF have changed. Gilston. And an example of this we saw very recently in the Gilston decision, which has been produced by Scottish Borders Council. I'm not complaining about the result, it's what it is, But I do complain about paragraph 121, which I'll read very briefly. I acknowledge the thrust of current Scottish Government policy includes considerable support for the development of onshore wind farms, recognised play a vital role, etc. However, that support is not unqualified. The current approach still reflects the need to undertake an assessment of the balance between environmental benefits and disbenefits on a case-by-case basis. At the present time, I consider such an assessment should still be based on the preeminence of the development plan. Well, that was a TCPA case. It may be, and this is the critical part of the paragraph, that the extent and urgency of the climate change problem will lead the government to alter the planning balance in order to place greater weight on the benefits as against any adverse impacts. If there is to be a, quotes, transformative change, end of quotes, as suggested by the appellant, this should be based on explicit government policy. As things stand at the present time, that policy in respect of the planning issues raised by onshore wind farms is based on MPF3 and Scottish planning policy. Well, I'm sorry, I think that's wrong. And that's what I'm saying to you today. I find that disappointing and difficult to understand. MPF4 is emerging and will need to reflect all the events and documents which Mr. Bell has canvassed. But we can't simply just pretend that the policy position is as it was in 2014. First of all, there is new law. There's the Paris Agreement, which the UK ratified in November 2016. There's climate change legislation. I won't go into the gory detail. You have it in the hearing statement. And in Scotland, there's a programme for government, which is a clear expression of government policy, as is the SES, the onshore wind policy statement, and we have now the Bayes CFD consultation. And we also have the Heathrow judgment, which says the Paris Agreement is government policy. How much more explicit could that be? SPP and NPF 2014 are dated and they're out of date in material respects, overtaken by explicit government policy. And I do invite reporters generally, and I invite you to recognise this in your report to the ministers. Business is very clearly not as usual, not as it was. And I say now, because to give other people a chance to respond, but I'll be saying in closing submissions, that indeed the need case for this type of development has been materially, significantly strengthened since SPP and MPF 2014 by the events which Mr. Bell has articulated. So I said I'd be unpopular, probably am now. Those are my thoughts.
Well, thank you for that. Borders Council, would you like to respond to that?
I'll respond. I mean, Mr. Trinick's obviously entitled to his opinion. It won't be the first time in my career I've had my about some decisions that come out of courts of law, etc. But it is what it is. That's the decision that was made. I mean, obviously, as he's invited, Sir and Ma'am, it's very much a matter for you what weight you place on these things. Make your report to the Scottish Ministers.
Okay, Andy Slothin.
Yeah, I mean, obviously some things have come forward since SPP and MPF 3 were published. That is being reviewed just now, as you'd expect, given it's coming to the end of its lifetime. I do think it is important, as the reporter recognised in Gilston, that you take climate change policy forward in a logical way, because you think there are ways that you could do that and implement that are going to impact very differently on different groups of people. I think it's important that you take people with you on the journey to net zero, because I suppose otherwise they'll just carry on emitting, or vote in governments that don't take it seriously. And personally, I think it is important that it is taken seriously. So I don't think you can just decide that you're going to put all the weight on that one thing. I think it is important to carry on retaining other objectives that are also important, like the landscape being one of them. I'd also just note that we didn't object to the principle of the turbines themselves, which we support, but just putting the lights on them, which could be avoided by as I understand it, application of money. And I don't know if the contract for difference might make a difference to that. I suppose you think, well, an ideal solution for us would be that we do have the turbines, we do get the energy generated out of them. We recognise that that's wanted, that's needed, but that we don't have to have a light on the top. And you think in this technological age, there ought to be a solution for that, especially if it's only one helicopter. I mean, I don't know if the range of things that could be done have been fully explored, but this is a bit off topic. But I think, well, if I can tell if my child has disappeared from a 1 mile radius with a phone that cost me £100, you ought to be able to tell that one helicopter's got close to a turbine and switch a light on at that point somehow. But I mean, I obviously don't have the expertise to know if that is in fact the case, but I do think there's a bit of room for exploring that, which has disappeared from the climate emergency to some degree.
Okay, thank you. Any further comments on that matter before perhaps we close for lunch?
Well,
it's 1:15. Shall we come back at 2 or 2:15?
Early is good. I mean, I think we're going to finish fairly early this afternoon. Half an hour is good for us, but you have your lunch arrangements to make, obviously.
45 minutes? Okay. Let's be back at 2 o'clock then, please. Thank you. Well, good afternoon. Before we move on to item 4 on the agenda, I just wonder if there's anything further anybody wanted to say under item 3, having reflected upon it over lunch, or shall we move on to discuss the development plan? Okay. Let's move on. Well, the first item under the development plan is the South East Scotland Strategic Development Plan. The hearing statements all noted the relevance of CES plan policies, Policy 10 and Policy 1B. And in addition, East Lothian Council lists the aims of the plan, and Borders Council draw attention to Para 125 and concerns regarding the cumulative impact of wind farms in East Lothian, Scottish Borders and West Lothian, and that LDP should undertake an assessment of the impact of development. Mr Bell comments that the policies of CES plan are of limited relevance to the consideration of the proposed development. So first I was going to ask the Council whether the assessment referred to in Para 125 as CES plan was undertaken as part of their preparation of their LDPs, and secondly whether they consider the policies that I've referred to be of limited relevance as suggested by Mr Bell. So I'll start with Borders Council.
It would be my understanding that in preparation of the local plan, that certainly paragraph 125 would have been taken into account. I do understand and acknowledge the point about the current role of CES plan, given the determination of the the proposed incoming CES plan. That's not now happening. Fundamentally, the SDP it's still a document. It's still there. It's not been taken off the table, as far as we are aware, and so it would still form part of the wider development plan.
And East Lothian Council.
I think the intention of CES plan was that we would work together with other councils to look at cumulative issues across the border, across the boundary rather. We did look at cumulative issues for the LDP for wind farm development, and we listed them in Appendix 2 of the development plan. Other than that, I would say, yeah, a lot of the CESPAN policy is directed at local development plans. It's instructions to local development plans rather than directly applicable to applications, I would say.
Mr. Bell, any comment?
Just agree with both positions expressed there. The LDPs give us the finer grain policy for development management that's relevant. And I think also just of note, SDPs will be going anyway under the new Planning Act. There's no primacy of a development plan in this case as well. So just two additional points of note when considering the SDP today.
Thinking about the Scottish Borders LDP, the Statement of Agreement notes that the key policies against which the development can be assessed are policies ED9 and ED5, and that the Renewable Energy Supplementary Guidance, which has statutory status, is also relevant. Could I ask you to comment on Mr. Bell's suggestion that the key consideration of policy ED9 relevant to this case is the second bullet under the heading Consideration of Wind Energy Proposals, i.e. landscape and visual impacts? Are other parts of the policy relevant?
Yes, I would say the application has to be tested against all those points as part of the assessment. It was our consideration that the proposed development complied with the vast majority of those points. However, it was that second bullet point, landscape and visual impact, as a result of the introduction of lighting. That was the element of the application that we considered that proposal did not comply. But certainly, we would consider it would have to be considered against all aspects of policy ED9.
And turning to EP5, do you agree with Mr. Bell that the effects of the proposed development on the special landscape area in question can be addressed in the context of policy ED9 and an assessment of visual impact?
Not necessarily, no. The site does fall within the special landscape area, so it would be my view that the proposal has to be tested against the requirements of policy EP5 as well.
And my only other question was whether there was anything other than the reference to aviation lighting on page 46 of the Renewable Energy Supplementary Guidance that you wish to highlight to us.
Probably just another point would be about the weight of the Ironside-Farah study that forms part of that SG on renewable energy. It has weight as supplementary guidance because it was considered as part of the SG. I think it's fair to say that at the point when that study was carried out, and I think the update was 2016. It sought to recategorise the typologies of the heights of wind turbines, and with the upper scale of turbines being 120 metres plus. Fair to say that the turbines proposed fall within that bracket. But I think the point is that the technology about wind turbines has moved faster than probably what we expected in 2016, and considering a 200-metre high turbine in the same category as a turbine which is 120 metres is maybe not appropriate anymore, and I think it probably be the Council's responsibility moving forward. We would expect to see a larger typology of turbine to be included in that type of assessment.
Mr. Bell, any comments on what you've heard from Borders Council?
I think I'll just maintain the position that ED9 deals with the matters that are in policy, the SLA policy, and that remains the lead policy in my view. In terms of the capacity study, I think it's a fair point that's made that if there is a next one, it needs to deal with the evolving technology that's taken place. But notwithstanding 120 metres as the upper level in that capacity study, I think it's important, and this is not a point in dispute, I don't think, that the Council deems the height acceptable, subject, of course, to the lighting issue. And the capacity study points to this location for the highest capacity typology that it deals with. So it's very supportive. That's all I would add. Thank you.
Okay, thank you. Turning now to the East Lothian Local Development Plan. Again, I note there's agreement that the key policies relevant to the consideration of the proposed development are policies WD4, which deals with access tracks, WD6, which is the decommissioning and site restoration, and DC9, which is on special landscape areas. And that's also non-statutory supplementary guidance on special landscape areas is relevant. However, I note that there's disagreement on whether policy WD3, which deals with wind turbines, is relevant. And I was going to ask, or could I ask, the Council to explain why it considers policy WD3 to be relevant when all the proposed turbines lie within the Borders Council area. I'll then ask Mr. Bell to respond to what you say.
I think it is relevant because part of the wind farm as a whole is in our area. It's also relevant in that it indicates how East Lothian will approach the sensitivities in its area, like the East Lothian landscape. An effect on the East Lothian landscape is as bad whether it comes from a turbine in the Borders or a turbine in East Lothian. So it's a guide to how we would approach a Section 36 application and what are the agreed sensitivities of East Lothian. It's also because it's been agreed by Scottish ministers that we can approve that. It's that's gone through a process of public consultation as agreed important things in an approach to impacts on our area.
Mr. Bell, your response.
Okay. I think we need to be quite precise when we're looking at the policies, and to say that it applies because part of the wind farm is in the East Lothian area isn't, in my view, correct, because there is already a separate policy dealing with tracks that is WD4, another policy dealing with decommissioning and restoration. This policy deals with freestanding wind turbines. Clearly, in this case, all the turbines are in Scottish borders. And even if this was a town and country planning case, Section 25 would not be engaged on these policies. It would not be the development plan. So the position I would take is that that policy cannot apply to development within the Scottish Borders administrative area. What it can do is inform us of the matters that East Lothian would have in mind when they were if they were examining such development in their area, but no more than that.
Thank you. Another question for the East Lothian Council. I was just wondering why, thinking of policy WD4, again, why that is relevant when the applicant is seeking consent to extend the operational period of the existing access tracks rather than promoting new tracks.
I think it was because there, as I understood the application, there was some possibility that there might be new tracks needed, but I may be mistaken about that.
Mr. Bell, is that the case?
No, I've put it, the table 1.1 at page 6 of my hearing statement summarises the development elements in each area, and the track references extend the operating period. That is what has been applied for.
Sorry, could I just say something else there, actually?
Yes, by all means.
It would be a maintenance programme as well, which we've asked for which is part of that policy. It's a WD4E.
Mr. Bell, on that point?
That's accepted.
Okay, thank you both for that. Again, a question for East Lothian. I've asked the borders, looking at policy DC9 and special landscape areas, I was going to ask whether policy WD3 is considered relevant to our consideration to the application. Sorry, if it's considered relevant to our application, do you agree that the effects of the proposed development on the special landscape area in question could be addressed in the context of that policy?
Of DC9 or WD3?
So it's WC9, sorry, DC9. So what I'm asking is, if policy WD3 is considered to be relevant to our consideration of the application, do you agree that the effects of the proposed development on the special landscape area in question can be considered or addressed in the context of that policy, because it deals with landscape and visual impact? Or is there another another policy that you would, or do I have to consider, or do we have to look at the whole of policy DC9?
Are you asking if we think that DC9 is relevant? I'm sorry, I don't know if I quite get what you're meaning there.
It's probably my fault for not phrasing the question properly, but there's agreement that policy DC9 is relevant. And I'm asking whether or not the considerations of the impact of the proposed development on the special landscape area can be addressed by addressing the points that are listed in policy WD3.
No, I think you'd have to look at the statements of importance for the special landscape areas as well. Appendix 2 might also be relevant of WD3, which is referred to in the WD3.
Mr. Bell, any comments on that?
I would say WD3 could be used for those purposes if you decided so, because I mean it's very rare to find a lead renewable energy policy in an LDP that doesn't take a holistic, comprehensive approach to wind farm development. So it refers to landscape impact, and within that term, one could bring in designations if necessary.
Okay, thank you.
That's a comment.
Just one final question on the supplementary guidance. The statement of agreement between the applicant and yourself includes a series of comments regarding the relevance of the Council's landscape capacity study for wind turbines in East Lothian. The exchange follows that in respect of policy WD3. Could I ask you, do you have anything further to add as to why you consider the study relevant to our consideration of the application, given what we've discussed about WD3?
It's referred to in WD3, and when we wrote that policy and we're considering whether to refer to the landscape capacity study, we had a look and thought, is this still relevant? Because obviously it had been done some considerable time ago. The first version of it with the larger, well, generally speaking, larger typologies, and then it was added to in 2011, but it was originally done in 2005. So when we did the plan, we thought, is this guidance still relevant, or do we need to redo it? And we thought it has a lot of information about the underlying landscape character, and even though the wind turbines are now larger, and there's more of them already in the landscape, so some of the information in there has been overtaken by events. But generally speaking, that is development. It's not a change to the underlying landscape underneath it, or the aims that we'd have for the landscape. So we did consider that to still be relevant, and for that reason, I think it would be useful.
Mr. Bell, do you have a comment on the relevance of the supplementary guidance, please?
My view is it's not particularly relevant in this case. We do have more up-to-date spatial guidance in the development plan, in particular in the spatial framework. And one point I highlighted in my hearing statement was the strategic capacity. It's effectively the area in East Lothian where there is strategic capacity at this location. And I think linked to that, there's just a remaining point to pick up in this statement of agreed matters that was discussed. In terms of the group status of the site, our position is that the whole site, for the development purpose, is Group 3, can be regarded as Group 3. In the comments from East Lothian on the evolving statement of agreed matters, there was reference to possibly some of the area being Group 2. I think for peat purposes, to be fair, that may be the case on some of the broad mapping, but in terms of the detailed EIA work that's been done on the site, that matter is entirely resolved. So our position is that, in effect, the location for the development can be regarded as Group 3, an area in which wind farms are likely to be acceptable.
East Lothian, comment on that?
As far as the site for the wind turbines themselves goes, yeah, I mean, that's in Scottish Borders Council, so I accept whatever their mapping says. But yeah, as for the section that goes through our bit, when we mapped it, we had to use the information on peat that we did have because we didn't have the mapping from SNH at that point. So we probably have mapped areas of peat which now wouldn't be included, because I think at the time their advice was to use any area which they said had any peat at all. But I think they've since gone back from that, and it's only like areas of deeper peat which are to be mapped as peat for that purpose. So it looks more Group 2E than it probably is.
So do you agree that it's Group 3 then?
Well, it's mapped as Group 2 well, parts of it are mapped as Group 2 in the development plan. So I guess because it's plan led, it is Group 2. But in fact, if you were to do it again now, it would be Group 3.
Just to finish on that, the Knock-on East decision, which we've lodged, was Mr. O'Brien, who was the reporter. It's CD 9.9. Similar issue, and broadly in his words, if the peat matter is resolved, the site can be regarded as Group 3. So that would be a helpful reference, I would suggest.
So what's the name of that decision again?
CNOC, and then lowercase an, and then uppercase E, and then AS, Knock-on East. I think it was from a couple of years ago. 99.
Okay, thank you for that. Well, that just takes us on to the last item, any other relevant matters, and I'll start with East Lothian Council. If there's things you'd like to say. Anything else that we haven't? It's your opportunity to bring to our attention any other matters that we haven't discussed so far.
I would just like to reiterate that we're not objecting to the turbines themselves or their location. The only thing we're objecting to is the presence of the lighting upon them. It's been a long-standing aim of East Lothian Council to avoid impacts on the Lammermuir skyline. That's shown in WD3E, which mentions the skyline in the recent justification for the policy. It's also in the landscape capacity study, where we've asked for wind turbine. Well, where it recommends that a turbine should be kept back from the northern slope of the Lammermuirs, and to mention also policy DP1, which is about landscape character. That, although that may look like it's written more for other types of built development like housing, and it was actually we did actually explicitly discuss when we were writing the policy as to whether that would be appropriate for wind turbine development, and we did think it would apply to that also. So it was intended specifically for that purpose.
I'll ask the same question of Borders Council before I invite Mr Bell to comment on what he's heard and any other matters that he might like to raise.
No, I don't think so. I think everything's been covered. I'll just reiterate what East Lothian Council have said, that similarly we're not objecting to the turbines per se. It's just the question of the aviation lighting that's required.
So, Mr Bell, we had a comment on the relevance of WD3E and also policy DP1, which we haven't previously spoken about. Your comments on whether you think they're relevant and any other matters that you'd like to draw to our attention.
Could I just take a reference there? It's WD3E. We're back to that policy. So I just need to get that before me to see the exact wording.
I think that's what Ms Squire said.
I added that one in as to show that East Lothian Council has had a long-standing aim to keep the skyline clear, and that's one of the places it's shown as WD3E, which is actually about tourism and recreation, but it specifically mentions the value of the skyline. And other places, the landscape capacity study, our responses to other applications, and the Appendix 2 about cumulative issues, and throughout the SLA descriptions as well. It was just to say that we do think it's important.
So I'll come back on the WD3E point. First of all, we maintain that the policy isn't relevant at all. At least it doesn't apply at all to development in borders, which it can't. And the policy is solely to do with turbines, not to do with access. But as far as E is concerned, I see what it says, impact on tourism or recreation, and then paragraph 481 of the reason justification, under E, it does say impact on tourism and recreation, including on various things, including landmark features of the Lammermuir skyline. But there's nothing to say about lighting here at all. I think this is written for daylight appreciation, nothing to do with darkness. So no, I don't see the relevance to this inquiry. I really don't. I think it's imaginative.
Okay, thank you for that.
Yeah, we've covered that point as well.
Yes, there was the issue of DP1. Yes, please do. Please do.
Firstly, it was the question from yesterday, excuse me, in terms of why the turbines are big, put simply. There is a helpful section in two documents. It's the EIA report, which is CD 1.3, Chapter 4, Site Design and Evolution. And paragraph 4.3.2 refers to scoping back in 2014. And at that time, 26 turbines at 135 metres were being examined. And paragraph 434 goes on to refer to that was reduced to 15 turbines. Now, that was at the 2015 gate check stage. Now, that was the time when the substays were withdrawn, that we discussed earlier. So paragraph 4.3.6 goes on to talk about the pre-scoping stage, 2016, with new market conditions, and looking at design parameters that would support a viable wind farm, effectively without substay. And the points are made in that paragraph about turbine efficiency increasing with height, larger, more productive turbines and so on. So that's a helpful paragraph. Then there is reference to paragraph 4.3.8 to scoping in 2017 for the current development. And at that point, it states that there were no serious concerns being raised by consultees on matters of height that might otherwise indicate that they could not support the development. Then paragraph 4.3.9, it refers to the existing development proposed. But importantly as well, one of the other documents that will help tell that narrative on height is the CD 1.2, which is the Planning, Design and Access Statement. And paragraph 4.7.13 of that document, it refers to the Scottish Energy Strategy, which talks about the need for improving efficiency in using taller turbines. And the government position within there states enabling these requirements is essential in order to meet ambitious but achievable targets. Then the last reference is at paragraph 7.4.17 with reference to the onshore wind policy statement, where it says that the Scottish Government states it will support new wind farms and recognises that if wind farms are to continue to contribute to government targets without subsidy, this inevitably means the use of larger turbines where appropriately located. So I would suggest that is an important recent policy hook justifying the design rationale that's set out in the wider EIA report. So I hope that's helpful on that point.
Thank you, Mr. Bell.
There's two further points before we deal with the policy point. One is one of the decisions, it's an English decision, I think it's the only one lodged, is Pond Farm, which is CD 9.32. There was one I was involved in North Norfolk back in, it was an inquiry in 2016, subsequently quashed in the High Court because the inspector didn't deal with cumulative matters. But it went back to PINS for redetermination. And at paragraph 88, the inspector deals with the District Council's declaration of a climate emergency. And he drew that as an important conclusion in rounding up his case. I just want to highlight that East Lothian has declared a climate emergency as well. The Council may want to respond briefly in terms of what that means for them, but I wanted to flag up that other decision makers are viewing that as a relevant consideration. The final point, but one, is in terms of the Council's reasons for objecting to the application. The hearing statement of East Lothian refers to not only WD3 but a water environment policy, and I just wanted to confirm whether that's simply a typo. It may well be, or whether it is a water environment reason. We don't think it is, but to be fair, I think it's worth clarifying that before we close the hearing. I think it's towards the end of the hearing statement where it refers to the policies that the Council contends the development fails. I do have a reference which I'll try and find in a moment, but while Ms Squire's looking at that, if I can just cover the final point, which is in terms of Mayshiel and that submission, which Mr Trinick said we would make a comment on by Mr Kelly. I think the only point to highlight in this hearing is paragraph 29 of the written submission, where Mr Kelly refers to constraint payments. That's grid constraint payments as a reason you should take on board, in his view, to refuse consent. Now, we would say that's not a relevant matter to take into account. Paragraph 165 of SPP makes it clear that grid capacity should not be used as a reason to constrain wind farm development or on decisions on individual applications. So I would suggest that would be worth referring to.
So do you want me to come on DP1?
I'll probably get East Lothian's response to the question about the water environment, whether that was a mistake or whether there's something in that.
No, it's not a mistake. The reason I put that in is because the policy is relevant to conditions to do with controlling surface water runoff. So that's why I put that in. It's not because I thought that the application would fail it. I just thought if we don't put the mitigation in, and that's the policy that you would lever that on. So that's why I put that in. It's not because I thought that it's not that I thought it can't be overcome. Because I mean that is mitigation that's suggested in the application, but just that's our policy reason for asking for the condition that we did on mitigation of surface water runoff.
Mr. Bell, are you content with that response?
Can I suggest if Mr. Trigg continues, I will find the reference. I think is still there. Thank you.
Just on DP1 and DP2, because the East Lothian policy hearing statement refers at paragraph 78 and 79 to both of those policies. And looking at the plan, page 146, the chapter heading is design, and I think you only have to look through the reason justification to see that they're talking about design of buildings, townscape, landscape character, historic towns and villages. This is all about new building in towns and villages, and the wording of the policies is quite clearly related to building new buildings. Landscaping, multicultural green infrastructure, position-orientate buildings, well-connected network of paths within the site. This has nothing to do with wind turbines, nothing to do with plant and machinery.
Okay, thank you for that, Mr. Bell.
Yep, I've got the references. Paragraph 105 of the hearing statement, where it says the impact of the lights is a step change. It will impact on several SLAs, also on dawn nighttime views. This is considered contrary to national policy as set out above and the East Lothian LDP policies WD3 and NH9. So that's the concluding position on policy non-compliance. My understanding is policy NH9 deals with the water environment as set out at paragraph 81 in the hearing statement. So it is perhaps an error.
No, sorry, that is a typo. I was looking at where I've said about the policy relevant to conditions about the water. I thought you meant there. Anyway, yes, you're right. That particular one is a typo. Yeah.
So just for completeness, what should that reference be? Or should it not be there at all?
DC9.
And I just wonder whether you had any comments on the what Mr. Trinick said about the relevance of policy DC1. Sorry, DP1.
Yes, I can say that it was written by the person that does do design with buildings, layouts, etc. But having done that, we checked and thought, is it relevant for other types of application? And one of the types that we explicitly considered was wind turbine development, and we thought that does the policy itself, which is the main thing over the reason justification, could apply to it and is suitable, because they didn't want to write something that would contradict what we were trying to do with wind. So it was explicitly considered when we, in the writing of that policy, whether it was suitable for or could apply to wind turbine development, and we thought it did. I mean, it was written too. Clearly, not all parts of the policy would be relevant, but those parts of the policy that are relevant, we did consider that would apply, or that it could be used for that.
Any further comments on that, or shall we leave it there? Well, that brings us to the end of the agenda on that session. So I suggest we perhaps take perhaps a 10-minute break. We can get ourselves organised for the conditions discussion. Thank you. Right, if we're all ready, I see we've lost Mr. Bell from the front table on that side, but we've gained one on this side, Mr. Kirk, who's joined you.
Yes, we've gained Dr. Andrew Tharm, who's an ecologist with the Council, and whose involvement will be required in some of the conditions which will be discussed.
Okay. So I didn't catch the name, probably.
Andrew Tharm, T-H-A-R-M-E.
Okay, thank you. Well, I think we can jump straight to item 2 on the agenda. I've simply intend to go through the conditions 1 through to 25, and then thereafter we can talk about the need for any other conditions before we talk about other matters. So to get us off to a good start, condition 1, I see there's general agreement on the terms of condition 1. Yeah, that's good. And on condition 2, the developments are commenced within 5 years from the date of the consent. And again, I see that the parties are broadly in agreement with the draft wording of that condition. Yeah. Right, there is a comment in the right-hand column from East Lothian with regards to condition 3 regarding the assignation, saying assignation must take place without the transfer. Sorry, is it must or must not?
That the assignation isn't done unless there is provision for any financial arrangements around decommissioning, then that's acceptable. I mean, and you hope they would do that before they signed it. It's just to make sure that happens, I suppose.
Mr. Trinick, any further comments? So, Mr. Gillis, I beg your pardon. Any comments on that?
No, sir, other than we would expect the ministers to ensure that the restoration provisions are appropriate before consenting to any assignation.
Right, with regard to condition 4, the serious incident reporting, the draft condition requires notification of any serious incident to the planning authority while the reason for the condition states that its purpose is to keep Scottish ministers informed of any such incident. The model condition refers to the Scottish ministers and the body. So I should say that the HOPS model condition refers to the Scottish ministers and the body of the condition. I just presume this was a drafting error, and that Scottish ministers should be referred to in the condition and the reason. Or is there some disagreement between the parties here?
No, sir. We don't think it's a particularly good condition, generally speaking, or entirely necessary. But if it's to be there, then I think it ought to be notification to the Scottish ministers. I think that's the wording in the model condition, isn't it?
Right, condition 5 refers to the radar mitigation, the MOD, and certainly Ms Hayward and I received the letter of confirmation from the MOD that they were content with the reworded or with the condition, and I suspect this is the comments here on the schedule are a consequence of comments being made before they had sight of that. The council had sight of that letter, so. Are both Borders Council and East Lothian Council, you've now seen the letter from the MOD that they are content with the draft condition?
Yes, provided. Yeah, it has been a couple of weeks since I've seen that. But yeah, provided that the wording in the proposed condition matches what the MOD were seeking, then we're happy with that. Yes.
And East Lothian?
Yes.
Right, condition 6 relates to deemed planning permission as proposed by the applicant. And I see there is disagreement with the drafting of this condition. The applicant considers the condition to be sufficient. Borders Council promote a number of amendments, while East Lothian Council would prefer use of the model condition. I also see that there's a factual error in the numbering of the turbines. Can I hear first from the applicant as to why the draft condition is considered sufficient before I hear from the councils?
Yes, sir. Perhaps before we do that, if I may, I think I intimated that we may wish to propose a further amendment to condition 6. Now, I have a draft of that proposed condition that I can, my colleague can circulate. So if that was what's before you, and I can explain what the additional proposed wording is, and then perhaps that would assist. So.
That would be good. Thank you very much.
Have the council seen this before?
Not the additional wording, ma'am.
Just take a couple of minutes to read through it. Okay. perhaps I could ask you to take us through it first. It may well be that, given the length and complexity and what you have to say, the councils may want to go away and consider their position on this, and we can deal with it then. So, but if you'd like to take us through the condition. Thank you.
Of course, sir. And of course, I fully accept that the council may require some time to consider it. However, having said that, it will be clear, hopefully, when I go through it, that it is only, although it's a fairly substantial Part 5, Parts 1 to 4 are as per the schedule. So the additional wording is Part 5. So, just dealing with Parts 1, 2, 3 and 4. First of all, we accept that the turbine numbers were not correctly stated, so they are in this revised text. Those are the correct turbine numbers, so thank you to SPC for pointing out that error. So far as the comments in the schedule of conditions are concerned, we consider that parts 1, 2, 3 and 4 are enough because, first of all, we don't consider it's necessary that there should be approval of the power rating and sound power levels of a candidate turbine once it's chosen. That's one of the matters that I think ELC and SPC are looking for. The reason for that is simply that there will be noise limits attached by way of a condition, and the development will have to meet those limits, and therefore it shouldn't be necessary to get approval of the sound power level and the power rating of the turbine. Secondly, we don't think it's necessary to add in consultation with ELC in this condition, and that's a comment that applies to a number of the conditions throughout, sir, because it's for SBC to consult as it sees fit, and no doubt they will consult ELC, but it doesn't need to be stated on the face of the condition, in our view. So far as maximum blade lengths and hub heights are concerned, and subject to what is said in Part 5 of the draft condition, again, we don't believe it's necessary to specify that rotor diameters and hub heights have to be approved, because the Planning Authority couldn't lawfully approve a choice of candidate turbine that went out with the scope of what's been assessed in the Environmental Impact Assessment report. And so far as the matter of turbine numbers on the turbines and any logos, we're content that there should be turbine numbers. We also suggest that it is helpful, because of the proximity of the existing crystal rig scheme and the Aiken-Gall turbines, it is useful to have a logo or otherwise to distinguish between the schemes in the event of an accident or something of that nature, and it being required to identify where someone is in the various developments. So, as I understand it, the crystal rig phases 1 to 3 already have logos displayed, so we're not really sure why that should be an issue for East Lothian Council. We don't also think the logos would be visible from East Lothian Council. So far as matters 1 to 4 are concerned, that's the applicant's position, sir. The explanation for the additional Part 5, which is what it amounts to, is a further restriction on the rotor diameters and microsighting condition, which appears later. The reason for that restriction is, as has been mentioned in a previous email, so there is a commercial arrangement between the applicant and the operators of Aiken-Gall wind farm, and in order to reflect the terms of that agreement, there is a need to further limit the rotor diameters of T1 and T3, and to ensure that they are not microsighted in certain directions. There is a planning justification for that restriction as well, in that the underlying reasons for that agreement are to preserve the efficient operation of the neighbouring wind farms. So I would submit that that is a sufficient planning reason to impose that condition, and it would also ensure that the contractual relationships between the parties are preserved. So that, in short, is the reason for Part 5 of the condition. It is all it does is seek to further limit the rotor diameter choice and the micrositing of the turbines. So I would hope it doesn't pose any particular difficulties for ELC or SPC.
Borders Council, are you able to respond to that now, or would you prefer to take this matter away?
If I could just quickly touch base on it. In terms of the revision to the original condition 6, in our hearing statement, we accepted the revised wording, so the change about the kind of power rating and all those aspects. We were happy with what the applicant said, so we were content with basically points 1 to 4. However, given that we've now got something further in front of us, we would ask for some time just to consider the aspect 5 of the condition, if that's okay.
That's fine. Thank you. And East Lothian Council, is that the same position for you?
I can understand why they want the condition 5, and yeah, we support that that you don't steal each other's wind, sort of thing, and that if you make an investment in wind power, you want the system to protect that investment, or at least not do things that will undermine it. I just want to say about the logos. The logo shown on, I think it's 5.1 of the application documents, it looks much bigger than other. If there are other logos on the existing turbines. Also, there's a condition on the Crystal Rig 2 that says no symbols, signs, logos or other lettering shall be displayed on any part of the turbines nor any other building or structures without the written consent of the planning authorities except for overriding reasons of health and safety, which I don't believe they have been, so I don't think there are logos, certainly of the size that would have been indicated by the drawing that's in the application documents, and probably would prefer that there aren't that writing on the nacelles is not visible from the ground. I mean, I think considering that you have to enter Crystal Rig or you can go from different directions, I think it's not very likely that you're going to confuse the two actually. Or if you have, it's going to be, well, you're going to need the air ambulance, which can't land at that point anyway.
Are you saying that it's just one phase of Crystal Rig, an earlier phase, but other phases have a logo? Or are you saying
I don't think they have logos on the turbines which are readable from the ground. On the nacelles, that's indicated in this application.
Any further comments on that? As it's just been pointed out to me, we'll be able to see for ourselves when we go on site. But
no, I don't think I do have anything further. So you will be able to see what is already there and also what's applied for in the application documents.
I think we can deal with condition 7 quite quickly. Design of ancillary development. I think Borders Council just wanted to add or qualify the word compounds. You said associated compounds. East Lothian Council wanted a few amendments. There was you wanted to change the first sentence to say take place, and you wanted to redraft the reason so that it better relates to the condition. And there's also perhaps a typo, correcting ES to EIAR. As I understand it, the applicant is happy to agree to the addition of associated compounds, and I think you're also quite happy to consider a redrafting of the reason. Is my understanding correct?
Yes, sir. We don't have. Of course, the reason should be accurate, and so we're not particularly concerned about any amendments to the reason, and we're happy with the addition of the words any associated compounds in the condition.
Right, we may have already covered some of the matters of import on this one with regard to community wind power, but condition 8 deals with micro-siting, and the suggested revised wording from the councils appears to be acceptable to the applicant. However, you don't agree to the reference to be made to SEPA. I'd be interested to hear from you on the comments that you received on the drafting of that condition.
Yes, sir. I think, again, it's a general point that we don't consider that it's necessary to specify with whom the planning authority should consult. It's up to them to decide. So I'm sure they will consult with SEPA, but it doesn't need to be specified on the face of it, sir. There is one other point in relation to this condition, which is that I think it probably requires to be made subject to Part 5 of Condition 6, if that is included, because that new Part 5 is a further restriction on micrositing. Yes, or indeed, sir, if it's tidier, Part 5 could be added to Condition 8 instead. But either way, I think there just needs to be a link between the two.
Board of Council, would you be content with that?
I actually wrote that down on the revised condition, so yeah, I would absolutely agree. I think it would be tidier to have all micrositing encapsulated in one condition.
Right, so that'd be your preference. And East Lothian, any comments on that? Could I ask East Lothian if you've any comments on that?
We just wanted to say we don't want them to microsite higher. So the X should be a limit.
You mean micrositing to a higher position on the ground? On the ground, you mean?
Yeah,
from one low place to a higher place.
Yeah, it shouldn't go higher. Yeah, I think that is the position in the Hops condition. I think that they don't go higher.
Sorry, sir, if I may, just on that specific point.
Yes, indeed.
I think that is a potential difficulty with the Hops condition, because absent any tolerance, upwards or downwards, unless you were building wind farm on a perfectly flat plane, then if you move, you may effectively nullify your ability to microsite if it involves moving the turbines, even a very small amount. And we are talking about the height of the turbine foundations. It's not a change in the hub heights or the tip height, it's the height above ordnance datum of the turbines as shown on figure 1.2, and in fact 1.2 doesn't show the heights above ordnance datum.
We have a solution to that one. Figure 1.2 doesn't really tell us very much. I think if you said that, I've just taken instructions on the amount, that no wind turbine foundation should be positioned more than 1 metre above existing ground level. That, I think, is a much better measure. The figure doesn't tell you anything at all.
Sorry, I don't understand what that means, Mr. Trinnick.
Oh, it's disappointing. Well, trying to do it by reference to a very small-scale figure that has no levels on it at all, plus or minus, whatever you can tell from the contours, isn't going to help you very much. If the objective is to prevent the development being higher than planned and therefore the tip height being higher than envisaged, ultimately, since the turbines will be on top of the foundations, then you need to relate the height of the foundations as finished to existing ground level. I don't see a better way of doing it.
Existing ground level where the turbine was originally going to be located, you mean?
Yes.
Okay.
And I've taken instructions, and there may be a very slight protrusion, but less than a metre, hence my suggestion of a metre.
Board of Council, what do you think to that?
It certainly seems a very small allowance for change, so yeah, I don't foresee there being any significant issues posed by that.
And East Lothian?
So what we're looking for is that they're not microsited to give a higher AOD to hub or tip. Probably have a metre above.
So that the wind turbine foundations, when finished, will not be more than 1 metre above existing ground level, i.e. local ground level.
So do you mean you could move it 50 metres up the hill and then put the foundation a metre above that? Is that what you mean?
Well, there are two elements to micrositing. One, where it's going to be laterally, and B, where it will be vertically. I'm looking at the vertical element of micrositing and saying that the wind turbine foundations should not be more than 1 metre above existing local ground level. That's all I'm saying.
So just to be clear, it's not just me that doesn't really understand this. Where the turbine is shown on figure 2.1, no, 1.2, sorry, 1.2, that location will have an above ordnance datum. And what you're saying is, wherever you microsite it to the next place, it can be no more than 1 metre higher than it would have been had it stayed in the first place. Yeah? That's what they say.
It just seems to be referring to the foundation, though, not the hub or tip height.
I'm just referring to the wording in the condition. That's what we're discussing, which actually says no wind turbine foundation shall be positioned, etc. That's what we're looking at.
So the overall permission controls the height of the turbines. You know, the actual how high the turbines are.
Have we got that right, that the foundation can move up a metre? If you have your existing ground level, which is something like that, say, whatever, your foundation can go along here or down here, but it couldn't go up here from its position on that figure. Is that right?
The wording may be imperfect. My excuse is I didn't write it. But what I'm trying to address is if you determined a turbine is going to be in position X, at that position X, the wind turbine foundations will end up being no more than 1 metre higher than the ground level at position X. There we are. That's all. Yeah, I'm trying to make the best of.
Sorry, no, you've lost me again now, Mr. Trinnick. That is not what I thought you were saying originally.
Oh dear. Well, look, if micrositing enables you to shift the infrastructure around to some degree across the ground laterally, when you end up at whatever position it is for a turbine, you determine where it's going to be on the ground, then the wind turbine foundations shall not be more than 1 metre higher than the ground level at that position.
Okay, that isn't what I thought you were saying before. I thought the council was saying, now correct me if I'm wrong here, but your concerns, both councils' concerns, that I think East Lothian articulated it, that you don't want it to go higher. In other words, wherever the new location for the turbine is, after micrositing, that location at ground level should be no higher than the ground level from where it's moved from. So because if it was higher than where it's moved from, then that turbine would look higher up and be more visible from East Lothian. I think that's your point, isn't it?
That is a point. Notwithstanding, that could also happen laterally, but...
I think you are talking about lateral movements. What you're saying is you don't want micrositing to enable the tip height of a turbine to be AOD higher than the position shown on the submitted plan. Is that right?
Yes,
that's a bit different from what we're talking about here. That's a separate issue.
I think she understands that, but her point basically was you can do all this, move them around here, there and everywhere within these limitations. However, if where you move them to makes them more prominent, in other words higher, then they're not happy with that. That's what they're saying.
Sorry, I think we are talking about different things. That's lateral movement across the ground. You've got a hill slope. If you go up the hill slope, they're going to be higher. That's what they're talking about. I'm simply looking at the foundation position. That's all. In the position you finally end up in. That's all I'm looking at. At least I'm looking at the wording of the condition before me. Bullet point 1, no wind turbine foundation, etc. That's the sole point I'm looking at. If I got it wrong, I apologise, but that's my understanding.
Okay, we'll give that matter some further thought as we consider our this application. But I'll perhaps move on from that now, unless you do have something to say.
I think you've understood what we had to say, but we would like it to be in the condition that it doesn't give a higher AOD overall height after micrositing.
So, at the risk of prolonging the discussion, only to add to that, the condition as drafted at the moment is not an absolute prohibition on a turbine ending up higher above AOD. It's unless otherwise approved in writing by the planning authority. So it does. Micrositing is subject to that restriction unless otherwise approved in writing. That's an important caveat to remain in the condition.
Sorry, you had something else to say?
I was just going to say, but I think they can microsite within this allowance without reverting to the planning authority. So it therefore could go up unless you took the view, which I guess would be an enforcement matter, that they'd breached the EIA regulations by putting something up that was beyond what had been assessed in the EIA, because it would be beyond the worst case scenario.
Well, 50-metre micrositing has been assessed in the EIA report. That has been assessed. And the East Lothian amendments to the draft condition did not include any reference to the topic now being discussed, which, in other words, the wording has been there. 50-metre micrositing from the position shown on figure 1.2.
I would just like to say we think it's been lost from an earlier version because I think we have mentioned that before.
Okay. Well, we've heard quite clearly what the parties have to say. We've made notes, so I think we'll move on from that one now. Okay. Right, condition 9 refers to environmental clerk of works. I note that the condition as drafted broadly follows the model condition. The Borders Council seeks an amendment or addition to the policy, particularly with regards to a preparation of a species protection plan and an ecological monitoring plan. As I understand it, the position of the applicant is that a species protection plan is not required, and that forestry containing the osprey nest, which I think is what is being referred to here, has been removed under an existing felling plan, and that also an ecological monitoring plan is not required because Clause B covers reporting requirements. So perhaps I'll ask Borders Council to explain their position in a bit more detail, and I'll invite the applicant to respond.
Thank you, sir. With regard to the condition as worded, the duties are imposed in Section A for ensuring compliance with ecological and hydrological commitments. So there's a condition, number 12, which is the Construction Environmental Management Plan, which deals with the hydrological commitments. With regard to the ecological commitments, I'm not aware that there's a dispute that mitigation is required. And if you consider Chapter 6 of the EIAR and Table 6.26 and Chapter 7 ornithology in EIAR.
Sorry, could you just slow down so I can make a note of those references? You go through them again slowly for me, please.
Okay. Chapter 6 of the EIAR, ecology, Table 6.26. And then in Chapter 7 ornithology, Table 7.21.
Give me that first table from Chapter 6 again.
It's Table 6.26. So in both those tables, there's a raft of mitigation measures set out, and it's referred to in the applicant's comments on this particular condition as regard to embedded mitigation. So also requiring is that the detail of that mitigation is provided in a separate condition. So as you've got a condition for hydrological commitments in condition 12, construction environmental management plan, you also have a separate condition which sets out the detail of the species protection mitigation.
Applicant, your response?
I'm not entirely sure what more is required beyond condition 9, sir, which deals with the appointment of an ECO to secure the commitments required in terms of condition 10 and 12, which isn't in dispute. Sir, and we've set out, as you've noted, sir, in the table, the reasons why we don't believe anything else, and in particular a species protection plan is required.
Okay, well, I've got a note of what you've said, and certainly I understand the applicant's position and your position, so that's been noted, and we'll kind of move on from that.
So with regard to the ecological monitoring plan, again, it relates to the mitigation measures, and also condition 10, which is the habitat management plan. So I think it's reasonable that if there's mitigation, you're monitoring the effectiveness of that mitigation, and therefore that can be included in an ecological monitoring plan. With regard to the habitat management, you're introducing habitat management measures, so you want to again measure the effectiveness in terms of achieving objectives of that habitat management plan. There's particular regard to protected birds of prey, goshawk and osprey. The applicant had made a commitment in the EIR for a monitoring plan for osprey. Well, as you've referred, the position may have changed regarding its presence in the location, and the environmental impact assessment recorded goshawk in the vicinity of the application. So there's no breeding pairs within the area immediately affected, but there's in the general area. So there's a requirement for pre-construction survey. So there's an uncertainty as to whether they're going to be affected by the developments. Really, the monitoring for goshawk would be subject to pre-construction surveys, and if they're found, some further ongoing survey to determine whether any mitigation implemented is effective. With osprey, the position may have changed, but I think the comments suggest that a platform has been provided so that they may be nesting in the local area, so are still potentially vulnerable to the development. So again, I don't think it's unreasonable to include a monitoring programme that includes osprey.
Okay, thank you. Any further comments from the applicant on that?
We're getting into evidence about ontological effects here. We're not careful. We're not in a session about that. We're simply in a session about conditions. We're totally unclear this side of the table. What is it you want, in addition to what's in the conditions now? Can you just be more specific about that, and we'll try and respond?
Council?
Is this a specific reference to the ecological monitoring or the species protection plan?
We don't quite understand what you're asking for. What is it you're asking for?
That there's mitigation proposed. I don't think that's disputed. And therefore, there's a monitoring programme to monitor the effectiveness of that mitigation. So there's a number of protected species that are present on site: breeding birds, badger, otter. Mitigation measures are to be implemented. So we're suggesting that there's a monitoring programme to measure whether that mitigation has been effective.
So does the suggested draft conditions that you've put on the table here, is that encompassing everything you're saying just now, or are you suggesting something over and above that?
No, as set out in the suggested conditions. Yeah.
So, condition 9 of the duties of the ECO, paragraph A, is to monitor compliance with the commitments required. So I think we rest on the view that that's enough as far as the commitments are concerned.
Okay, well, as I said earlier, we've noted your comments. We have the suggested draft revision and the schedule here, so I think we'll perhaps move on from that point just now. Okay. Now, we may encounter the same kind of debate with condition 10 about habitat management plan. Again, I note that it broadly follows the HOPS model condition. Borders Council again is seeking an amendment or some additions to the wording, and that has been suggested and is set out in the draft schedule. The position of the applicant, as I understand it, is that monitoring and management plan is not required, as mitigation is embedded into the proposed development. So again, I'll perhaps ask the Council to briefly explain why it is seeking what it is seeking, and then I'll ask the applicant to respond.
Thank you. So, with regard to the habitat management plan, policy EP3, local biodiversity, has a requirement for no net loss of biodiversity. So the EIAR sets out the habitat loss of various habitats present on site. So at a minimum, we would require that those habitats are compensated for in a habitat management plan. And in accordance with good practice for a major development of this type, then it is usual, it's typical that there is a habitat management plan which provides not only compensation but enhancements. And there is guidance out there from, particularly from the likes of Scottish Natural Heritage, on habitat management plan requirements, which has a particular focus on wind farm developments. And a note in SNH's response to the application on the 14th of August 2018 that they strongly recommended a habitat management plan for habitat management and enhancement.
Mr Gillis, your response.
So our position is, in fact, that there's no need for any habitat management plan at all, because per the comments in the condition table, no significant effects were predicted for any species or habitats in the ecology chapter, and subject to embedded mitigation, effects on 3 species of invertebrates were reduced to negligible. So, in short, there's no impact that requires to be mitigated by way of a habitat management plan. It is true that SNH said that they would encourage the imposition of a condition requiring a habitat management plan, sir, but that's not, in our view, a reason for such a plan. It may be something that SNH would like to have in this case, but it's certainly not something that we consider as necessary, because there's no effects identified that require to be mitigated. And given that the effects are not significant on any species or habitats, would suggest that that doesn't give rise to any need for measures to ensure compliance with the policy that was mentioned.
But there is a habitat management policy condition actually here in this schedule, and you say no development shall commence until a habitat management plan has been submitted. So is your position that that should be struck out, or is it?
Our position, sir, is that it isn't necessary. It is in there as the wording that if sir, you consider that a condition ought to be recommended to secure a habitat management plan, that is the condition that we would consider as appropriate. So under deletion of the additional words there shown in track changes. But our primary position is that there is no requirement for a habitat management plan at all.
Okay, I understand the position of the council and the applicant, and I think we'll probably move on to the next condition. I see that condition 11, redundant turbines, that has been amended as per the suggestions from the council. So we're content with the wording of that condition.
Yes, sir.
And condition 12 is about the preparation of a construction and environmental management plan, including construction method statement. Again, the draft wording broadly has been agreed between the parties, save for the phrase, it's not necessary to expressly require consultation with East Lothian Council. I think you've made that your position on that matter quite clear. And then there was an exchange from the schedule there, which I can see relates to the preparation of a drainage layout plan at this particular stage in the process, and that this is best done by an appointed contractor. Is that still the position of the applicant?
Yes, sir, it is.
Okay, I note the points of the council on that matter, and we'll give that due consideration. And again, in condition 13, there seems to be broad agreement. It does follow the HOPS model condition. The Borders Council agree with the wording, but suggests that reference could be made to a written scheme of investigation detailing a programme of archaeological works. East Lothian Council have kind of suggested something along the same lines. So just interested to hear what the applicant has to say about that.
So we don't have any particular difficulty with the substance of what's being asked for. I think the general principle that there should be a written scheme of investigation to be carried out by suitably qualified archaeological contractors is accepted. So it may just be a case of amending the proposed condition simply to refer to a written scheme of investigation and a programme of archaeological works to be carried out, including the measures set out in that condition, which is to be submitted prior to commencement of development.
Okay, thank you.
Could I just add some comments that we've had from our archaeological advisor? I understand that most of the development obviously is in Scottish Borders Council area. It was just to say that he did stress that it was important that the written scheme of investigation was reported to the council so that we have some control over what happens once the written scheme of investigation is in place.
Well, I know that the condition as drafted does include the phrase submitted for the written approval of the planning authority.
I think it's once it's been approved, it needs to be reported on so that we know if they've done it. I think apparently that has been quite important in making sure that the work is carried out according to the written scheme of investigation.
Well, the draft policy then continues to say the approved scheme of archaeological work shall thereafter be implemented.
I think it's to be reported as well. I think it's added that in the condition and reported upon as per the agreed terms of the submitted WSI.
Mr. Gillies, any comment?
Only that the condition requires the written approval of the planning authority, which, on the basis that part of the development is within East Lothian Council, would include East Lothian Council in this case.
Okay, I've made a note of the positions and I understand what you're saying. Okay, thank you. Right, condition 14 relates to traffic management plan. Again, Borders Council agree with the wording of the draft condition, but suggest an informative that describes what the traffic management plan should address, whilst East Lothian Council suggests amendments in addition to that proposed by Borders Council. The applicant does not consider the Borders Council requirements should be included as a redrafted condition. I'm not clear if you're content with an amendment to the condition or whether it should be an informative. And I note here that you don't actually agree with what East Lothian Council is suggesting, so it'd be interesting to hear what you have to say about that, for the comments received to that condition.
I think our observations so far as Scottish Borders Council are concerned are just that we don't consider the level of detail that they've set out in the condition actually requires to be on the face of the condition, so it could be in the traffic management plan to be submitted to and approved in writing. It should be obvious what that plan should look like. I don't think we had any other issues with because all Scottish Borders have really done is set out the matters that the traffic management plan should incorporate or address. So in substance we don't have a particular difficulty with that, we just believe that should be in the scheme rather than on the face of the condition. So far as East Lothian Council is concerned, we think no development shall commence until is better than no development shall take place unless. So far as the proposed addition to the reasons, I don't think that is appropriate for condition 14, because there is a condition later on which deals with repairs, extraordinary repairs and so on. So I think that's what's being alluded to in the proposed addition to the reason to allow fair apportioning of road repair works, although I'm not entirely sure. And I'm not quite sure what the addition to bullet point 6 is getting at. Is this bullet point 6 in Scottish Borders Council's list? Well, again, I think so far as that last point is concerned, I think that would be subsumed in our general observation that this detail can just go into the traffic management plan. So.
I think also, sir, if you're tempted by the Scottish Border's wording, there is some drafting, tidying up to do. The sentence, this will ideally be by way of a Section 96 agreement, doesn't really sit happily with condition wording. And a programme for the works is required to ensure the avoidance of conflict. That's too vague to be enforceable. So if you are tempted, I think you need to tighten it up a bit.
Thank you for that. Is this the condition that would deal with, and forgive me if I should know this, where dilapidation or kind of works to the network would be carried out, or is that, does that come further on as you suggested?
It does, sir, as you'll see later on. I guess the last condition is road dilapidation, sir, so that's dealt with in a separate condition.
Okay, moving on to condition 15, which deals with abnormal loads on trunk roads, and indeed with condition 16. I've noted that the part...
sorry, I just wondered if I would get a chance to say anything about what they just said about our comments on the previous one. If you don't want me to, that's fine.
Far away.
Where we've asked for take place rather than commence, the reason for that is because we've had it come up that if you say commence, that anything after it's commenced is lost. If the development commences and that hasn't happened, then you can't do anything further with that condition. And that's why we've asked for take place unless throughout. The reason why we want the traffic management plan, the reason to be added about fair apportioning is that we can't apportion fairly the repair of the road unless we know what traffic is using the road. So unless the traffic management plan is there and includes reporting of how many vehicles are using it, then we can't do that. So that's why it's important to put that as a reason for that condition. And adding in decommissioning, I suppose that's obvious that there could be traffic for decommissioning as well as construction. So thanks. Thank you.
Any further comment, Mr. Gillies, on that?
No, sir.
Okay, point noted. Okay. As I started to say, condition 15 deals with abnormal loads on trunk roads, and 16 trunk road signage and temporary controls. And I see that there's agreement between the parties on that. Condition 17 is construction hours, and that the parties agree with the addition of a clause to deal with HGV movements. Is there any comments on those, or we're content with?
We're content, sir.
Okay. Condition 18 deals with private water supplies, and the suggestion here is that a new clause is added to the condition to address the Borders Council concern regarding water sampling and abstraction.
We're content with that as well, sir.
Okay. Right, condition 19 deals with the issue of aviation safety. The parties agree, subject to a new paragraph requiring evidence to be submitted to the planning authority that relevant information has been submitted to the MOD, Defence, Geographic Centre and NATS. Sorry, is that the position? Nothing's changed on...
That is the position, sir. This condition sits alongside condition 20, sir, and I do have something to say about that condition, so it may be as well to take them both together.
Indeed, okay. Obviously, it's been the topic of the inquiry session, and there was circulated prior to the inquiry session a redrafted condition. Perhaps you could take us through that, and we can then invite the councillors to comment.
Sir, before I do, and I hesitate to say this, but we have made very minor refinements to the condition, which I can circulate a further draft of and then explain. They are minor in the extreme, so they haven't changed the substance, but my colleague has, I think, copies for East Lothian, Scottish Borders and for yourselves. So,
okay.
Thanks, sir.
Let's take us through it.
This condition follows on from the line of evidence which you heard, sir, about the possibility which emerged late in the day following the recent response from the CAA, in which it became apparent that there was at least the possibility that an infrared lighting scheme might be feasible, but subject to certain things being achieved. So, having considered that, and this is all set out in the notes, or having considered that, the applicant suggests a mechanism by which the contribution that we talked about earlier could be secured, and that, and also suggests a mechanism by which, in the event that the objective of allowing the relevant helicopters to fly with NVG equipment is achieved, that either infrared lights are installed, or if they've already been installed, they can be switched to infrared, which I gather is possible with certain types of lighting. So the way in which the applicant proposes that could be achieved is, well, there's two aspects to it, sir. So far as the contribution is concerned, which we have proposed would be £100,000, we suggest that that could be secured either by a scheme to be submitted to the planning authorities for approval, and the scheme would set out the detail of the payment, the timing of the payment, who it's to be paid to and in what circumstances, and when the offer would be withdrawn. And we've outlined the main terms that we're proposing in the notes, but essentially what we would envisage is that the offer is there, and once evidence is put forward that the expenditure has been incurred and the aircraft are ready to fly with NVG capability, the 100,000 would be made available. If it's not used within a period of time after commencement of the development, the offer would be taken off the table, but it's a reasonably long period of time, sir. Now, there's a bit of detail in there to be worked out. That is not appropriate for a condition. In theory, I suppose it could be dealt with by way of a scheme to be approved, but in fact, it may be that you consider that the better approach would be a Section 75 agreement to secure that part of the obligation, which of course could deal more with the financial aspects in a way that perhaps a condition probably shouldn't. So that's the first limb, which is the securing of the offer of 100k and the circumstances in which that will be made. The second part is to be dealt with by way of the conditions, and that's set out on the second page of my note there, the two additional parts of the proposed lighting condition. So in the event that before development has commenced, Scottish Borders Council receive confirmation from the Scotland's Charitable Air Ambulance that the relevant helicopter service can operate using NVG capabilities, and separately, and this is also important, obviously, approval from the CAA for that, for an infrared lighting scheme, then the applicant will only be required and will only install infrared lighting in accordance with any approval. Part 2 deals with the situation where these confirmations and approvals arrive after the scheme has become operational, in which case any visible aviation warning lights could be switched off. It's important to add into the condition, for the avoidance of doubt, I think, that the applicant's fallback position remains the 4-turbine visible lighting scheme, or the 4 visible lighting scheme. So Appendix 1 to this note, sir, just for the avoidance of doubt and to make sure it's all in one place, is the proposed condition 20. Now, it doesn't, aside from the bits that deal with the NVG capability, the condition is the same as or broadly the same as the condition that was posed in the table. The only difference is that we've set out the specific turbines which are to be lit. So Part A deals with the MOD requirement, which is for infrared lighting only, and their confirmation that that's acceptable is lodged as a document, sir. Part B deals with the CAA visible lighting requirements, which are now for 4 turbines to be lit. We have, and this is a point which is picked up on by Scottish Borders and East Lothian Council, we have suggested that the specifications of the lighting should be fixed by condition, hence the reference to tables 1 and 2, which are the ICAO specifications. Now, the reason for doing that, the reason for limiting the flexibility is to give comfort as to the precise type of lights that are going to be installed, so that you have confidence that the condition requires lighting to be installed of a type which matches the specifications of the lights that you've heard evidence on. So I know that the councils perhaps quite sensibly suggest flexibility in the condition, but we think in this case certainty is actually a benefit here in terms of the specification of the lighting. The rest of the condition makes clear what will happen in the event that the ability to use only an infrared scheme is achieved, and that's parts 3 and 4 of the condition, sir. On the last page of this note is the aviation charting and safety management condition, sir. This is actually a duplication of condition 19. Essentially, it's the MOD requirement for information to be provided. So if you're going to include condition 19, then that additional part, it doesn't require to feature there in condition 20, sir.
Okay, thank you for that explanation. Borders Council, any comments?
Again, it's probably one that would merit having a closer look by ourselves, given the late changes. I'd like to welcome the fact that the applicants are consistently trying to kind of find an appropriate solution in terms of the wording of the condition, and a couple of the changes on the face that have been made seem to address some of the minor issues already. I think I suppose our kind of main point here is making sure that the impact of the lights is minimised as much as possible, and the kind of suitable way to do that is through the wording of the condition. We obviously made, in our original response, made reference to the wording of the condition that was attached to the Viking wind farm in the Shetlands. I think in one interesting point I took from that was the purpose of an ongoing review. So once the development became operational and the lights had been installed, that if something changes further down the line in terms of lighting technology or even policy, that there was recourse in there for us to go back and amend the lighting, potentially removing it completely if we are able to do that at a later date. So yeah, I think we'll probably just have a look at the revised wording and I think with a thrust of making sure that can happen.
So is it yourselves that lodged the Viking? Have you lodged the Viking decision?
I believe so. Yes.
It is. East Lothian, any comments?
Yeah, I mean, we'd have to have a good look at it as well. But I think we are, like Scottish Borders, keen that there is provision for review, and there's also provision that the applicant has to proactively seek that. To keep it under, I don't know how often you'd ask for it, but to make sure that it's not, because where it says in 4, it says that written confirmations and approvals are received by Scottish Borders Council. I mean, is that any obligation on the applicant to actually seek out those those different consents, or keep the situation under review to see if that can be changed. And I think that should be included as well.
Would you be content for the councils to take this away and give it some further thought? And yes, and the comment about the ability to review.
I think that's in there, unless I'm misunderstanding the point, that paragraph 4 simply says in the event that the written confirmations and approvals referred to in the paragraph above are received by Scottish Borders Council after the development becomes operational, any visible warning lights will be switched off. So there is the potential for installed visible lights to cease to be visible. And answering another point in paragraph 3, well, Scottish Borders Council themselves can be proactive if they want. All the condition says is that in the event prior to commencement of development, the council receives written confirmation as set out. I won't repeat it. So if that is received, however it's procured, then the condition takes effect. But certainly, I mean, do come back to us. And you do, excuse me, just a minute, what number? No, hang on. Excuse me. Oh, so it does. There's one omission just from this table that in 1B it says turbines 1, 3, 6 and 7. I think you need to add in there on EIAR figure 1, 2, so we know where to find these figures, the turbine numbers. And also in 1A, turbines 8 and 11, reference to figure 1, 2. I think it may be help if we provided a slightly tidied up copy of this for you.
That'd be helpful, thank you. And my intention would be that, you know, once a date is set to reconvene to hear Scottish Borders Council witnesses, that might be a good time to get all the comments on these conditions in by, so that we can have an opportunity to have a further discussion if need be on those. Okay. Moving on to condition 21, which is about replacement of forestry. The consultation from Forestry Scotland was an objection. They commented that there was no information on compensatory planting, and that further discussions were required between Forestry Scotland and the two councils to agree areas of compensatory planting. Yes, I was saying the condition 21 relates to replanting of forestry, and I can see from the draft schedule here that there's quite a number of comments made by the two councils, and indeed there's quite a bit of text highlighted in red. Perhaps I could ask Mr. Gillies just to take us through that condition as to what you have agreed with, what you're in agreement with the councils, and also how you're addressing the objections of Forestry Scotland.
Thank you, sir. Well, first of all, we are in agreement that there is a need for a condition, and that the condition should provide for a scheme to compensate for the removal of up to 26.7 hectares of woodland. I think the main difference between the applicant and SBC just relates to the detail of what is to be in the scheme, and there's two aspects in which we disagree with SBC. First of all, we don't think the detail of the scheme needs to be set out on the face of the condition, which is a similar point to the point I made earlier. The scheme will be whatever it is, and if SBC consider that it is missing something that it should have in it, then no doubt they will tell the applicant before they approve it. But perhaps more fundamentally, the draft wording of Condition 21 proposed by SBC proceeds on the assumption that compensation can only be secured by replanting elsewhere. And the applicant does not agree that that is the only appropriate means of compensating for the removal of up to 26.7 hectares. There are many examples of other schemes whereby compensation can be achieved by other means other than replanting. And it's very important that the applicant has the flexibility to come up with an appropriate mechanism to compensate for the removal of forestry that may not include replanting. It may, but there may be other options. So there is that is an approach that's been endorsed by the Scottish Government previously. I do have a letter here, sir, but it's not before you, so I'll not go to it in any detail. But it's a letter from Fergus Ewing to the applicants confirming his understanding that there are many different ways in which developers are currently securing compliance with the relevant policy by way of compensation for loss of forestry. So I think, in short, we don't think the detail needs to be in the condition. If you feel that some signposting of what's to be in the scheme should be on the face of the condition, then we think it's important that the condition doesn't proceed on the assumption that replanting is the only option. So if it's going to specify what's to be in there, I think it also needs to say or such other measures as may be approved to secure compensation for the loss of forestry. So that's the key concern for our clients, because they don't want to be bound to identify appropriate land holdings and keep them in reserve pending construction or whatever. There needs to be more flexibility.
And any comment on the East Lothian response to the draft condition, Mr. Gillies?
No, sir. These appear to be more minor points, just subject to my general caveat about not having a condition that requires only replanting as a means of compensation.
Okay, Borders Council, are you content with what Mr. Gillies has had to say?
So regarding the first point about the detail provided in the condition, my understanding this is based on the ECU, so standard condition, which they took advice from what was Forestry Commission Scotland, now Scottish Forestry. So really it's for the avoidance of doubt of what's required in a submission under that condition. And in our experience, we've had a great variety of planting schemes submitted, some with very scant detail, and it's a fairly tortuous process of teasing out the relevant detail to get agreement on it. So it's for the avoidance of doubt, really. It sets out exactly the level of detail that's required for a compensatory replanting scheme. Regarding the second point, I'm not actually aware of any other mechanisms for for compensating other than through replanting. Our policy is policy EP13 for trees, woodlands and hedgerows, which has a requirement for compensatory replanting. That's further guided by the Scottish Borders Woodland Strategy Technical Advice Note. And that relates or reflects the government's policy on the control of woodland removal from development, which does require, as far as I'm aware, replanting. I mean, we have an example of a replanting scheme for a wind farm development under which the council has undertaken the replanting as part of the discharge of conditions, which relates to the Penman Shield wind farm. And in that particular scheme, the heads of terms of a replanting scheme were agreed with the applicant, and there was an understanding that the council will take on the responsibility of delivering that under a Section 69 agreement. And we're still in the process of delivering that particular scheme, but I'm not aware that there's been any discussions at all with the applicant about a similar proposal in this case. Thank you.
So what was the name of that that wind farm proposal? And is any details of that before us?
No, it's the Pemmon Shield wind farm, and it's a Pemmon Shield compensator replanting scheme. I'm not sure whether the decision notice for Pemmon Shield is a production. No. Okay.
Perhaps I'll ask Mr. Gillis to respond to that before I invite East Lothian to comment.
Sir, we're not aware of the detail of the Penman Shield scheme, but it may be something that we could look at in the period between now and the reconvened inquiry, sir.
Thank you. East Lothian, any initial comments?
As we said, and I think the applicant agreed, we would like, prior to the commencement of development, to be replaced with no development or felling of trees. It shall take place because we've had instances of trees being felled because that's not development, but they can do it under planning consent before the agreement of replacement planting. So that's why we requested that. I also think, in the interest of transparency, it would be useful to have the replanting scheme put in the condition. There has been a lot of interest recently in East Lothian about people wanting to plant trees. They do see it as important as addressing the climate emergency, and I think it would be useful to have it in the condition, just so that they know it will be done and what will be done.
Mr. Gillis, a comment on that?
No, sir, I think you've got our position on that.
Thank you. Yes, condition 22 deals with access management plan. I must admit, when I was looking through the schedule and the comments, I wasn't entirely clear how the applicant has responded to those comments, so I could invite you to enlighten me.
Yes, so I can see why that may be the case there. I think this is the only instance where this happens on the table, but what we've done here is revised the proposed SPC condition. So our changes are those shown in tracking in the middle column. So subject to those proposed changes to what SPC are proposing, we're content with their proposed condition, and we've set out the reasons for our proposed changes.
Council okay with that?
Yes, we're happy with that. We confirmed that in the hearing statement on conditions.
Okay, thank you. Condition 23 is decommissioning and decommissioning method statement. I think there's agreement that the policy should refer to planning authorities, but also East Lothian Council had a comment, I think the second sentence, decommissioning should not preclude removal of all elements of the proposal within East Lothian, including access tracks, cables, cable routes and drainage ditches. Mr. Gillies, your comments on that?
I think this is one of these comments that falls into the category of matters that would be set out in the proposed decommissioning method statement, which will no doubt set out best practices at the time, because as I understand it, it is not always the case that complete reinstatement of tracks, cables, cable routes and so on is required or recommended as a best practice measure, but that I think would be a matter for detail of the proposed decommissioning method statements, and it needn't be prescribed in the condition.
East Lothian Council, any response to that?
We agree that it might not be best practice at the time when it comes to decommissioning, but that time is at least 35, well, more than 35 years from now, and it's impossible to predict at the moment what that is. And we think that the condition should clearly state that decommissioning does not preclude everything being removed, because that might be best practice at the time.
Thank you. Condition 24 relates to the bond. Again, there's the comment that the condition should read planning authorities, which has been agreed. There's obviously a debate around scrappage value, and I have to confess I'm not familiar with this argument, so I'd be grateful to hear from you what you think about the comments that's been received from the councils. Mr. Gillies.
Thank you, sir. First of all, there's no dispute that it's appropriate that there be some bond or other financial instrument put in place there. The purpose of that is to secure the cost of the decommissioning of the site, sir. So that's all accepted and agreed. And the question, I think the only difference between the parties is on the valuation of the bond and what it should or shouldn't take account of. And the applicant's position is that the turbines themselves and the other infrastructure on the site will have a considerable salvage value, which should be taken into account when calculating the amount that has to be provided for by way of the bond. Now the figure for the salvage value is not fixed for all time coming, because there's a provision, or there will be a provision in the scheme for a review on a regular basis to ensure that the level of the bond is adequate, taking into account matters such as the salvage value and so on. So that approach we suggest is reasonable. I understand from my clients that in relation to phase 3 of Crystal Rig, a financial provision has been put in place which does take account of the salvage value of that scheme already. So there's precedent, I'm told, for that already in East Lothian Council in respect of the Crystal Rig 3 development. So we don't really understand why that should be an issue in this case. So, and it isn't the case that the Planning Authority is exposed to some risk that the bond wouldn't be sufficient, because the review mechanism will ensure that the amount that's set aside is always appropriate, and that any fluctuations, if there are any, in the value of the materials on site will be taken account of.
Okay, thank you for that explanation. Borders Council, your response.
Thank you, sir. Yeah, as Mr. Gillis says, I don't think we're too far away from here. I agree with most of what he says. I think I spoke to the officer within the council who deals with these things, and I think it's just his practice and the council's practice that what he looks to do is he looks to set a figure which will protect the council if the council has to clear the whole site at the end of its life. And he tends not to accept scrappage value, and I understand from him that's been accepted on a number of occasions. But that is just council's practice. There's no policy, there's no guidelines which says that should be accepted. It's simply the council's preferred option that scrappage value should not be included.
But it would appear that it was acceptable in an earlier phase of Crystal Rig.
But that's for East Lothian Council, I believe, sir.
Right. East Lothian Council, you got any views on this?
Firstly, I would like to say that we are not scrap metal merchants. We don't have a scrap metal licence, so from that point of view, we couldn't sell the turbines ourselves. We're not that happy about having them taken into account, because you don't know the ownership of them, which might be separate from the land. I suppose what we're seeking, ideally, is that we have almost an undo-it plan, so that we can, similar to what you would set out for your construction, for a deconstruction, so that we could have this thing, thump it on the desk of a contractor, and say, give us a price for decommissioning, and they go off and do it without us having to do any further thing. And that would let us price the bond at a reasonable amount, so that we know exactly what it should be. I don't know what we've done with Crystal Rig 3. I think probably did take the scrappage, but I know there's been discussions ongoing over Crystal Rig 2 with the reviews of the bond as to whether that should be taken into account or not, and how much it should be.
Well, unless the applicant wants to come back at all, I understand the position of the party, so I'm content with what I've heard. We can perhaps move on to the final condition. It's about noise, and I think, Mr. Gillies, you intimated yesterday that you might have a revised condition for that, or have I misunderstood? No.
No, sir, at the moment. No.
But there is, okay. So, but there is agreement between the parties on the,
yes,
on the wording.
Agreement.
I beg your pardon.
Yeah.
I beg your pardon.
Okay.
Not to worry you. Right, the next item on the agenda was the need for other conditions, and the schedule that I have before me has a suggestion for a radio and TV interference condition and one on road dilapidations, which we've alluded to earlier. Are these conditions that the applicant is content to add, or is there some... sorry, I beg your pardon. I can see here that you consider them not to be necessary. So perhaps you could explain to me why.
So far as the TV and radio interference condition, so there's no evidence that there's likely to be an issue. There is an existing wind farm of approximately 90 turbines which don't give rise to TV interference issues, so we don't see a need. It's not necessary to impose a condition for, to mitigate something that isn't likely to happen. So far as, just taking them both together, so far as the road dilapidations condition is concerned, well, the Planning Authority does have statutory powers which would be sufficient to secure the repair of any dilapidations caused to the roads. However, we think it might be useful to have the condition, at least because it will allow a survey pre and post construction to ensure that if there are any extraordinary repairs required to the road, it's only those attributable to the development, because there may be other developments taking place, sort of which the applicant would not want to be responsible for.
Of course, we heard from Mr. Bruce yesterday. I think one of his comments was about road conditions generally not being that good and not often repaired. East Lothian Council, you want to comment?
Yes, I think he's actually accurate in that, and part of the reason for that is it's very difficult for us as a roads authority to know when to repair the road, because obviously there's been different developers using it for different applications, and we don't want to. I mean, it's actually quite complicated to apportion it correctly, because it's not like one comes in, does the damage, goes away. It overlaps, so you don't want to repair the road only to find it's just about to be destroyed again by the next one. So it's quite difficult to judge when to go in and fix it. So that's been part of the cause for complaints, I think, is that you don't want to spend, and some of it would be public money, on repairing the road when it's about to get destroyed again, especially if they've done a survey and showed a destroyed road, and so obviously you'd only have to bring it up to that condition, not a good condition. So so it has been quite complex, I think, and I think there is some kind of agreement, I think. I mean, my colleague didn't go into details, but I think there is some kind of agreement between the operators of Crystal Rig and Aikengall about discussing what to do with the road, because I suppose it's in their interest to keep it fixed as well, because they obviously go up and down it. So I don't know the details of that, but I think there is some arrangement. But yeah, I mean, I suppose our interest in it is to make sure that if there is damage to the road, it can be fixed. Because I mean, in the first place, that road was not. It was built for like farm traffic and residences. It wasn't built for heavy, a lot of heavy wind farm traffic.
Thank you. Borders Council, you didn't. The schedule doesn't indicate any response from you. Is this an issue for yourselves?
No, it's not. There was just the additional points that were raised by our ecologist, Dr. Tharm, which we've spoke about already, so happy with that.
Okay. Well, you can see the applicant here is suggesting that that they would be prepared to agree to a condition to ensure a pre- and post-condition survey is carried out. So I think that would perhaps satisfy certainly East Lothian's concerns. And microphone, sorry.
Sorry. Our roads colleagues have said the roads conditions that we set out in our response, they want to make sure that everything in those is covered. That's their interest, and to basically to make sure the road is fixed and the residents aren't annoyed.
Any further comments, Mr. Gillies?
We can't guarantee what people would be concerned, but the Roads Act cover the position anyway. We are bound to put right all damage caused by abnormal traffic. B, we agree to pre-construction surveys and post-construction surveys. I don't see how that's not belt and braces.
Sorry, so there is one further point as well, if I can add to what Mr Trinick has just said, which emerges from what Mr Bruce said yesterday, which is the request I think he made for a community liaison group. So the applicant is content and would be content with a condition requiring such a group to be established. And that may deal with some of the issues of relationships so far as transport is concerned.
Yes, thank you for reminding me. I did make a note to ask you that, but beat me to it. Thank you. The fourth item on the agenda was really just to help me, really. If there was somewhere you could direct me, or perhaps compile a list of all the plans and documents that would be that you're looking for approval, so that would be very helpful. Thank you.
Can we just be clear about that? Because this is Section 36 application, not a TCPA application, and the only submitted plan is the one sent in with Section 36. So when you say you want a list of plans for approval, can you be more specific as to what it is you're after?
I was just looking for a consolidated list of the documents that would accompany our report. Yeah.
Sure, we can provide that. That's fine. I understand.
Thank you very much. The fifth item was put down for a need for an obligation or other legal agreement. I think we've touched upon that in our discussion on aviation lighting. I don't think there's anything else that would be the subject of an agreement.
There's only one other item in terms of legal agreement that stems from our archaeologist, their consultation response. They identified that the development would have an impact on the Yardley stone circle, and in order to mitigate that impact, they recommended a financial contribution. It was noted in their response as trying to pursue that through a planning condition. That's something that we weren't content with, and subsequently felt that if that was to proceed, then the way forward with that would be via a legal agreement. There has been other offsetting of archaeological impacts by way of financial contribution within the Lammermuir area previously, so that would be what we would look at in terms of mitigation.
Has this been discussed with the applicant, or is this news to the applicant?
There's an indirect effect, isn't it? Not a direct effect.
Yes, yes, that's correct.
What are we compensating for?
My understanding, it is the setting of the Yardley's stone circle as a result of the positioning of the wind turbines. There should be some coverage in at least the report of handling on that matter, and certainly the council's archaeologist in their consultation response.
If it would assist, sir, is this perhaps something we could circulate to the applicant and could be for further discussion when we reconvene?
It'd certainly be helpful to have it set out. I hadn't come across this before. Perhaps I have read it, but it's escaped my mind. So that would be helpful. Thank you. Right. Last item, item 6. Is there any other matters which party would like to draw to our attention on the conditions? Perhaps I'll start with East Lothian.
No, I think I've said everything.
And Borders Council?
No.
And the last word to the applicant. Anything further to add?
No, sir.
Well, declare this session closed. Oh, yes.
Can we discuss resumption date?
Indeed, I was going to come onto a list of things. Yes, there's a number of things that we'd like to discuss before we leave. One's about arrangements for site visits tomorrow. What arrangements we've been put in hand for that. And as you say, when we might reconvene, I think I provided Mr. Gillies with a set of dates when Ms. Hayward and I would not be available.
Yes, thank you, sir. And I've discussed those dates with our team, and I have intimated them to SPC and ELC, so I don't know what their view is. We've identified, on the basis that Mr. Welsh needs to be here, 2nd of April would be the best date for him. We're reluctant to allow things to drift into April because obviously there's school holidays and so on, and then, well, at that point we start to get into other things and so on. So, if possible, we'd like to do it this side of April. I gather the schools week begins the 4th of April or thereabouts. So the 2nd of April would be fine for our team. I don't know about the councils, however.
Borders.
It's 2nd of April seems fine by me. Obviously, Catherine, Andrew's availability is crucial, so I need to explore that, and I'll obviously endeavour to do that this week, and hopefully we can get some movement on that, if not by the end of this week, certainly by the beginning of next week at the latest. But I think her availability is pivotal to all of this.
And East Lothian?
Yes, we're all right with that.
Okay. It's difficult to predict, of course, but we're thinking when we might conduct a site investigation of the wider area, looking at some of the dusk and nighttime views. Any further thoughts when we might do that?
First of all, on the site visit tomorrow, the word from the site is they're expecting snow on the site tonight. If that happens, they won't be that happy to conduct people tomorrow on site. So I think we have to make a judgment call on that now, and the advice we're getting is it doesn't sound a good idea. Apologies.
That's fine. Is there any indication when it might clear? I haven't looked at a forecast. I mean, whether yeah, just wondering if it's something that could be done later in the day.
I can certainly speak to site. The forecast for tonight is not good, so they'll make a call in the morning about whether access is allowed, and that picture might change through the day, but it will be very much a last-minute call as to whether access is permitted and whether they put any restrictions on that access as well. Because they've already... Yeah, they've already pulled for today the site technicians back into the office because it's not safe for them to work. So.
Okay, so what I'm taking from that is it's probably best not to do a site visit tomorrow, and perhaps we'll have to identify a day. I don't know. We'll have to get our heads together. If you give us a few moments, we'll see when we might be able to do that. Okay.
In terms of other site visits, certainly, if we go ahead on April the 2nd, then a day either side of that would be good for some of the site visits, and maybe the dusk and dawn. If we don't want to leave them much later, because then dusk does get up to 8 o'clock at night, and yeah.
I think we'll leave the visit to the site itself, and perhaps until when we reconvene. I think that's probably the best thing to do.
In terms of the dusk and dawn visits, do you need Catherine Andrews at that?
Don't think so. I wouldn't have thought so, no. She's been, so my understanding is she's been at the various site visits.
Yes, but to accompany the reporters, I was thinking. But should we have email exchanges, of course, in the next few days to try and narrow down a date as soon as possible when you can do that?
I think that's a good suggestion.
Trying to do it in the room is going to be difficult, I think.
Yes.
Yeah.
Yes, I'm just being reminded, obviously in the run-up to this week, there was a lot of documents submitted to the office. We're not confident we have everything in electronic form, and we certainly don't have what you lodged with us this morning in electronic form. So it'd be good to get, for completeness, that would be very helpful. If you could do that for me, thank you. Okay, that's everything I have. Anything else? Thank you very much. Thank you.